Good morning, guys. Good morning. Good morning. The state has responded to I don't know if it's a response. I think they put something in, but it's a motion they put in. But she put it in late. I thought it was a response, but it's a motion she put in. I hope Sylvia don't see that comment. What comment? What comment, Paris? What comment? You know I'm gonna look for the comment. What comment? Okay, let's go. Can we get the likes up, y'all? Come on, y'all. Let's do. Hey, Big James. Hello, everybody that's coming into the chat. Hi, everyone. I just we got a motion that just dropped. I see it's something that's late because it was supposed to have everything done yesterday and it was sent today. So let me go. Hold on. Got this. My glasses got something on it. Hold on. My glasses got something on it, y'all. Sorry about that. All right, here we go. All right, let's go. I'm gonna go ahead and read this for you guys. And it's from Love, y'all. Let me make it bigger. It's a notice. And it was filed 11:21 p.m. yesterday. Okay, so they filed 11:21 p.m. So they're trying to get something in. It seems kind of like another petty stuff, but we're gonna read this together. All right. All right, let's go. I need to go into this thing here. All right, if you guys type in, I won't be able to see because I'm on this screen and I don't see anything, okay? It says State of Georgia versus Jeffrey Williams, and then it has the case number, indictment number 22SC183572. Judge Paige Reese Whitaker, notice. It says notice. The state hereby notice the defendants in this case and this honorable court of the following. It has come to the state's attention that on May 2nd, 2017, this honorable court issued an order to recuse with regards to a motion for a new trial in State versus Quantavious Greer, case 10SC92920. Attorney Brian Steele, Esquire, was Greer's attorney on record at the time. The facts underlying the prior case were unrelated to the present case and are not part of this case. The prior case involved the December 22, 2007 murder of James Yarborough. The present case involves all allegations of criminal activity by and through members of YSL, which formed years later in 2012. So what the heck does got to do with that, y'all? 2007 and 2012, what does that have to do with the price of tea in China? But anyway, on information and belief, the recusal order was based upon the court's prior supervisory role over the appellate unit in the district attorney's office during the she's being petty. She's being petty. She's saying the judge was the supervisor over the appellate unit in the district attorney's office. So therefore, there was a conflict of interest. So she's basically trying to ask the judge to remove herself. Okay, here we go. During the pendency of Greer's motion for new trial, That order might even have been issued in error. As the amended motion for a new trial, Mr. Steele filed on Greer's behalf on December 2016 before the order of recusal, already listed the same judicial officer who ultimately resolved Greer's motion for a new trial in 2019 after the order was of recusal. She's being petty, y'all. She's being petty. Although Greer was a co-defendant in the present case, Greer pleaded guilty in the present case on November 2023. The state provided this notice simply as a point of information. Really? Respectively submitted the 23rd of July 2024. Adrian L. Love. Did y'all see that, y'all? What do you think? What do you think? What's that all about? What do you think that was all about? We're going to read that again. Hold on. We're going to read that again. We're going to read that one again. Okay? We're going to dissect this slowly by slowly by slowly. We're going to dissect it slowly by slowly by slowly. You hear the way I said it? Slowly by slowly by slowly. Slowly by slowly by slowly. We're going to dissect this thing slowly by slowly by slowly. Okay, here we go. Let's go back up. Notice, y'all. Notice. The state hereby notices the defendants in this case and this honorable court of the following. It has come to the state's attention that on May 2nd, 2017, this, talking about the judge, this is talking about Paige Reese Whitaker, this honorable court issued an order of recusal with regards to a motion for a new trial in State versus Quintavious Greer. Did y'all hear that? It has come to the state's attention that on May 2nd, 2017, this honorable court issued an order of recusal with regards to a motion for a new trial in State versus Quintavious Greer. Is Quintavious part of this case right now? Wasn't his case already handled, y'all? Isn't Quintavious' case handled already, right? Yeah, that's unfun. Yeah, isn't his case already handled? So that has no bearing. That has nothing to do with what's happening right now. I'm just asking for a friend. Well, so basically she's saying that the judge and Steele were individuals that was part of this previous case, and so the judge recused herself from the case with Quintavious Greer, where he was seeking for a new trial from his conviction. Okay, that's what it's basically saying. Okay. And it says the case, she gives the case number 10SC92020. Attorney Brian Steele, Esquire, was Greer's attorney of record at the time. The facts underlining the prior case are unrelated. Here we go. They got a key answer right there. Unrelated to the present case. So why are you bringing it up if it's unrelated to this present case? What is your reason for bringing this up? What's the reason if it's unrelated? What is the purpose of you bringing this up? What's the purpose? You said it's unrelated, so you just want it for information purposes? Okay. All right. And are not part of this case. Unrelated and not part of this case. This is what we said. So why are you bringing it up? The prior case involved the December 22nd, 2007. Okay. 2007 murder of James Yarborough. The present case involved an allegation of criminal activity by and through members of YSL. So she's trying to put some sort of connection to something that happened in 2007 to YSL criminal activity. And she's saying basically that Quantavious Greer was a member according to, the conspiracy and criminal activity, but this is 2007. So 2007 bearing and stuff like that has nothing to do with this case. In fact, the statute of limitation is beyond past, right? But she wants to bring it into this thing to bring some awareness, I guess. I don't know. But she's bringing it up. And then she also says that the YSL did not form until 2012. But she's still putting a connection of members, but the membership supposedly didn't start until 2012. So what does that have to do with this? I'm still trying to understand why the purpose of putting all this extra stuff in this, and it has nothing to do with one thing or another. Okay? Now listen to this. This is what she said. On information and belief, the recusal order was based upon what? The court's prior supervisory role over the appellate unit of the district attorney's office. So the reason why she removed herself because she had a previous position in the appellate unit of the district attorney's office. So she felt that she did not need to be on that because of her previous position. So she should remove herself. So are you trying to ask her to remove herself here, or are you just digging for straws? Just asking for a friend. During the pendency of Greer's motion for renewed trial, that order might even have been issued in, oh my Lord. Oh my God. Then she says that the order might have been issued in error. So an erroneous order, you bringing it up. Why? Why? As the amended motion for the new trial, Mr. Steele filed on Greer's behalf in December 2016 before the order of recusal. So the order was incorrect, right? But you're putting this in here. Why? Why? Already listed the same judicial officer who ultimately resolved the motion for a new trial in 2019 after the order of recusal. Although Greer was a co-defendant in the present case, Greer pleaded guilty in the present case in November 2023. The state provided this notice simply as a point of information. Respectfully submitted 23rd day of July 2024. Yeah. You guys see that? So, guys, you want to have a conversation about this? All right, let me go read what you guys were saying, what some of you guys are saying. Y'all been chatting in this chat today, this morning, haven't y'all? Oh, Lord, it's a lot. I missed a lot. Hold on, I'm going back up. Hold on. Let me go back up. Keys, good morning. Let's see. Let me see what some of you guys are saying. Let's see. I'm just going through some of the comments you guys are saying. Nothing love, just one of those people likes the sound of their own voice. 2017 before 2012. Did she mean 2007? uh, uh, okay, hold on. We're going to look at this. Serena, hey. Victoria, she submitted today with yesterday's date too. I think it just rolled over because it was late and the system rolled it over. Okay. Okay, yeah, sorry. Jacob, funny. Jacob, you are so funny. Oh, Lord. There was never about RICO. It was about trying to get Jeffrey Williams off the street, and now the state has dug a hole and they're trying to get out, Carmela said. Let's see. This case has nothing to do with any clients it has represented in the past. Nothing to do with this case. Fannie must be in here to win at any cost. I'm just reading your messages over here. Just bear with me. I'm trying to catch up with what some of you guys wrote in here. At this point, dismiss this case is what Adrian says. M says, let's see. I just pulled up. I was shocked to hear yesterday that your channel was mentioned in this case. Have y'all talked about it yet? We did that yesterday. We read the motion when we saw the link. It had my channel on it. It's from Adam's interview with me. See, good morning. Nisha says, hold on, y'all. Love, stop embarrassing yourself. People of the state, get her some help. She's unhinged and desperately needs her. Quick, seriously. Okay, wait. Can't wait till the 30th. There's gonna be some fireworks, y'all. She's trying to muddy up judge name and or taint the new jury. It's not a new jury, not as yet. Okay, it says we want new judge. She wants a new judge that will let her run amok over the right of the defendant. Michelle says she's trying to get extra credit before she submit the original homework assignment. In fact, it wasn't even a response to that. It was something she added on in here. Hold on a second. Hold on. Point of information, waste of time. Move on, child. You guys y'all treacherous up in here. Y'all treacherous. Y'all, dude, danger. Nisha, you on the road. This is a point of information that love shouldn't have filed. Pointless. Stop overreaching. Oh, Lord have mercy, y'all. Unknown says love has had to a so-called family member emergency now the gag order motion. What's next for the bully? Oh, okay, y'all. Y'all just like, oh, okay. She's definitely being petty. The state filed a lawsuit. They didn't want no committee to take place to get rid of corrupt DAs. And Judge Whitaker was the one that denied the lawsuit. I just went back and read from the beginning. Is it me or does love need a basic writing? I ain't saying nothing about that because I'll be stepping on my own toes. So I ain't saying nothing about that. I have nothing to say about that. She knows the judge is not gonna go for her. Her finishes and her attitude. Sylvia, did you read her response on still? No, she hadn't done a response on still. It's not a response on still. Did they just post it just now? Did they just post it just now? Because you just put it at 10:54. Okay, so let me see. I didn't know it was a. Did it just now? Hold on, let me go check. Hold on, y'all. Let me see if I can get it right now. Just bear with me a second, guys. Okay, I got it. I got it. I got it. I got it, y'all. I got it. All right, I got it. All right, y'all ready? This is the state's response to Steele's. Thank you. Thank you. Thank you, Arlise. Thank you so much. I appreciate it. You guys be on it, y'all. All right, let's go. I'm going to put it up for you guys to see. All right, here we go, y'all. Let's go. Hold on. I gotta make this bigger for y'all. Is that bigger? Can y'all see this? Bigger, bigger. All right, let me go. All right, let's go, people. All right. State response in opposition to defendant Williams' motion to challenge factual finding. Following the recusal of Chief Judge Glanville, precipitated by motions from defendant Kendricks and Williams, defendant Williams has filed a motion to challenge the factual finding made by Judge Cross in her order recusing Judge Glanville. For the reasons cited below, the state respectively moved this court to deny the relief defendant William motion requests. In support of this motion, the state shows this honorable court as follows. Background. Defendant Kendrick and Williams each filed motion to recuse Chief Judge Glanville from this case. In support of their motions, each defendant submitted an affidavit or affidavits. The recusal motion was assigned to Judge Rachel Cross. On July 17, 2024, Judge Cross ruled on the motions and entered an order containing written finding of facts and conclusions as required by Uniform Superior Court Rule 25.6, here within Rule 25.6. 2. Legal authority and application of law by Judge Cross. Rule 25.6 governs the requirements of recusal order. The rule grants to the judge considering a motion to recuse discretion to either rule on the motion considering solely the affidavits or to convey the evidentiary hearing. Rule 25.6 requires that the judge considering the motion to recuse rule on the merits of the motions and make written finding and conclusion. Judge Cross considered the motions to recuse solely on the affidavits submitted by the defendants, and as required by law, Judge Cross included in her recusal order written findings of fact and conclusions as mandated by Rule 25.6. Even when the motion to recuse has no merit, if a judge is perceived as refuting a charge of bias, the judge's action creates a bias for recusal. Judge Cross wrote that in transferring the cases to another judge for consideration, Judge Glanville necessarily determined that recusal might be authorized if the fact alleged in the motion were assumed true and Judge Glanville was prohibited from opposing the motion. Judge Cross agreed generally with the Judge Glanville's assessment of the propriety of the ex parte meeting, but found that Judge Glanville created a basis for his recusal when he added facts, provided context, questioned the veracity of allegations, and otherwise explained his decision and action and argued why those actions were proper. Judge Cross found that in presenting his record as to the recusal issue and ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegation, mandated his recusal. Number 3, lack of authority for Williams' motion. Defendant Williams asserted in his filing that Judge Cross made 2 findings that are erroneous in her order recusing Chief Judge Glanville. I'm not going to read that footnote. Should I read the footnote? Okay, let's read the footnote. C. Isaac versus State 257, Georgia, and in the case number stated, we recognize that judges may be solely tempted to respond to motion to recuse, which they perceive as gratuitously defamatory. We also recognize that a judge who actively resists a recusal may be fully capable of even-handedly presiding if the motion is denied. Nevertheless, we think these factors are heavily outweighed by the necessity of preserving the public's confidence in the judicial system. We therefore hold that after a legal sufficient motion to recuse have been assigned for hearing, the judge against whom the motion is directed may not oppose the motion. First, defendant William objects to the order reference in his recusal motion inclusion of hyperbole. That reference to hyperbole is accurate. More importantly, the reference to hyperbole is itself a factual finding and is not a material issue for litigation. Second, defendant Williams asserts that Judge Cross's finding that the hearing in chambers was not improper is wholly against the law. That assertion is clearly incorrect. The hearing in chamber was regarding a witness's immunity and compelled testimony. Such a hearing without the defense present has been held to be proper by the Supreme Court of Georgia, which ruled the defense has no standing to be present at such hearing. 4. Conclusion. For this reason stated above, the state moves this honorable court to deny defendant Jeffrey Williams' motion to challenge factual finding, respectively submitted the 23rd day of July, 2024. S. Adrian Love. Okay, let me see something. Hold on. She sent that one at 11:21 too. So she sent that one late. No, but she still has until Friday to respond. So she's good. She's good in that one. All right, so that's that. It's hyperbole. Okay. Even if you put the enunciation, I didn't see it because I was on another sheet, so I couldn't even see it. So it was too late. But thanks anyway. Appreciate it. Trash waste of email and paper. That's what AJ said. All right. Guys, no timing out, people. Just delete messages. No timing out, people, please. Friendly reminder, guys. Mods, if you were not in the meeting, you probably gonna have to get your wrench taken because we spoke about that in the mods meeting. We're not timing out, folks. We're not timing out, folks. We're not timing out, folks. One of my mods time out somebody, and I won't call you out, but please, I just saw the timeout. Please do not time people out. You timed them out for 86,000 seconds. Now that's outrageous. That was really outrageous. Not necessary. That was very outrageous. And you were not in the meeting, so don't do that, please. Please don't do that. Do not time people out with those outrageous numbers. Pete says she's saying the recusal was for public confidence. Okay, so question on that one. That's a very good statement, Pete. Okay, so does that show some sort of non-confidence that's going on with the public? That means it's something underhanded going on, that they don't want the public to feel that some underhanded stuff is going on. That's why they decided to do the recusal. Is that the reason why? Is it the notion of something evil is going on, and they don't want they want to and so it's I'm just asking the question. She wants to make sure the public has some confidence in the judicial system, so they it's like you see is the look of evil is there, so they're gonna remove it. No, I was just asking you, Pete. No. You're giving your opinion, but that's why I'm shining a light on it, because I wanna really talk about that, because so are they saying there's evilness that's looked upon? So the public right now, this is showing that there's something that's possibly going wrong. So we don't want the public to see it looking terrible. So we're going to remove it, not because it's not terrible. It's because we just don't want it to look terrible. Is what you're saying? We just don't want it to look terrible. But if you know for a fact it's not terrible, why not just leave it? Or is it because there's a look that it really looks bad? Okay. Thank you, Pete. Thank you for responding. All right. I wasn't trying to come after you. No, I was just asking you a question. Good morning, Kat. Not Williams. Good morning. Good morning to you. So I'm going to put the link in for those who wants to join in. Come on in. Let's have a conversation about these things, because I guess we're going to be seeing stuff dropping left and right. We're going to be seeing stuff dropping left and right for the next couple of days, I believe, because they're trying to get these stuff out, because she has until Friday to respond. So I think since it's a volume of stuff. They want to start, put them out right away. Can you read the motion from yesterday? Charlie, which motion? I hope you're not trying to get me to read all of them. Because then I'm gonna have to get my reader to help me. My 2 mics and a 2 voice, 2 head and a mic, something like that. Get her to come back up here. I go, Pastor. You know he always come up here. I can always rely on Pastor. Hey, Pastor.
Hey, Miss Sylvia.
Hey, how are you?
Miss Sylvia, I think I got you on the screen.
Yeah, turn me down back there. Turn me down back there.
Where's my remote
at? Tipsy wants me to read the last one again.
Short. I learned how to be short. Hold on, let me turn the YouTube off.
Yes, I didn't understand the other motion you read. Which motion? Which one are you talking about? Which one? Which motion? Y'all pushing the button over here now. Y'all really pushing the button. Which motion? Which motion, Pete? And which one did you want, Tipsy? Which one? Y'all just putting so many things. Footnotes 3 to support the defense not needing to be there. Footnote 3, okay. Typo means information. Variant. Read the last one again. Which one? The last motion? There go my buddy AJ. Oh, I'm trying to figure out what they want. Pete said, I didn't understand the other motion you read. The motion, the response one, y'all, because we talking about so many things. Too many of y'all. The response one, y'all. AJ, I hear myself on your thing.
I just muted it, my bad.
Okay. Let's see. There's so many messages in here. I'm trying to figure out the first one. Do you want me to reread the first one? The one where she's saying that there was an old case that the judge was on. That one, because there's 2 things I read. That's the one you're talking about, right, Pete?
Yeah, I think he's talking about the first one you read, that real short one.
Okay, I'm gonna go back and read that one again. Okay, so y'all want me to read both of them? Okay, because Tipsy wanted me to read one thing and Pete wants me to read another thing.
I mean,
see, y'all.
They're a total of 4 pages.
What are you trying to say?
That she ain't had nothing to say.
Well, they want me to read again. You know, they're really pushing the button here. You know that, right? They really pushing the button here. They really want me to use my non-reading butt up here. They really want me to read, and I don't know how to read. Okay, here we go. Woosah, Lord have mercy, Father. Just help your child. Okay, here we go. I'm just going to start from notice. The state hereby notices the defendants in this case and this honorable court of the following. It has come to the state's attention that on May 2nd, 2017, this honorable court issued an order to recuse with regards to a motion for a new trial in State versus Quintavious Greer. Case number, who's that with that? Is that you, Pastor? Could you stop that noise? 10SC92020. Attorney Brian Steele, Esquire, was Greer's attorney of record at that time. The facts underlying the prior case are unrelated. You hear that? The prior case was unrelated to the present case and are not part of this case. The prior case involved the December 22nd, 2007, murder of James
Yarborough.
Yarborough. No, somebody just sent me a text. I know the name. I was just reading this text. Let me put my phone down because folks be sending me messages. All right, James Yarborough. The present case involves allegation of criminal activity by and through members of YSL, which formed years later, 2012. On information and belief, the recusal order was based upon the court's prior supervisory role over the appellate unit of the district attorney's office during the pendency of Greer's motion for a new trial. That order might even have been issued in error. As the amended motion for new trial, Mr. Steele filed on Greer's behalf in December 2016 before the order of recusal. Although already listed, the same judicial officer who ultimately resolved Greer's motion for a new trial in 2019 after the order of recusal. Although Greer was a co-defendant in this present case, Greer pleaded guilty in the present case in November 2023. The state provided this notice simply as a point of information, respectively submitted the 23rd day of July 2024 as Adrian L. Love, Chief Deputy District Attorney. All right, I got it. I got it. You got that one? All right. Thank you, Mike. 2 heads and 1 mic.
Good morning, y'all.
Good morning.
Good morning.
2 heads, 2 legs, 2 mics, 2 ears is here.
Thank you. You want to take the second one? Do you have that one? Or do you want me to send it to you?
Which second one?
The one that I just read. Hold on.
No, I don't have it.
Not the one I just read. The other one. Hold on. I'll send it to you right now. Just bear with me, y'all. Let me send it to the 2-headed monster.
Chat, Chat, do y'all think that motion had any substance in it?
No.
No.
I think it was a waste of time.
And then at the end, now that you reread it, she came off condescending at the end, like just letting you know in case you didn't know
That you were part of it. Just in case you didn't know that it was you.
You feel what I'm saying? Like,
but it don't mean anything. I just want to bring it to your attention.
Yeah, but the excuse me, the real kicker is Glanville's the one that sentenced him. So why was that okay?
And she didn't mention that part. Like, come on, y'all. Like,
right. Glanville sentenced him, and this notice never came about in all the months of trial. So there was a conflict there with Glanville then as well. So I'm pretty sure Whitaker's going to see that.
Yes.
Glanville's the one that sentenced Greer?
Correct. To 10 years. So once Whitaker take a look at the whole case, she left out a big piece of information on who did handle the case.
The same thing Love always been doing this whole trial is cherry picking the information she wants to let out if it don't fit her narrative.
What Love is doing right now is justifiable means to something else. If we have not learned about Love and her actions right now, a two-page document, and she's being condescending in it, and she knows she is. Like, everyone knows their own attitude. She knows what she's doing. So it's something else that she's gonna try to do. Either that or she's stonewashing to see what the defense motions is gonna be. But she know that this judge, from her laugh and giggles, is something about someone when they do a lot of laughing and giggling and talking. They basically telling you, okay, I hear you. I want for you to think that is a joke, that is a game, but it's really not. Okay, so she knows she's not going to be able to get away with her tone, her rhetoric, um, everything that the judge said. The filing motions late. She knows that that's not going to take place. So it's something else coming. There's something else coming, and I want to know. I want to see what her response is going to be with the motion to recuse herself from the case itself.
I mean, shout out to Todd Glass. She mentioned earlier, like in Steele's motion, he even had a motion to recuse her and Hilton. She didn't even respond to that.
Yeah,
she could at least responded to that with some kind of case law or something.
She's waiting because Brian Steele got some other motions. AJ, you know how Steele's and them gonna get. She's waiting. She probably already got it. Okay.
Steele was on that case, so Steele is definitely going to come forward.
Oh yeah.
Just like he was on the appellant case that she cited in court. He said that's not what happened. I was on that case.
Ma'am, we're waiting for you to read. That's what we're
I
waiting
got
for.
it.
We're all up on a different conversation. Let's stay focused, people. Focus.
Okay, I asked you the question, ma'am. I said the motion, and you want the response and not the motion,
response.
correct?
The response, because I read the other one already. Response.
I already have. You might have missed it. I said I'm ready. I'm just waiting for you to put it up.
I heard the pastor talking. I heard AJ talking. I heard you talking. Can we get going now, people? Thank you so much.
Lord, I'm not two heads today. State of Georgia versus Jeffrey Williams. State's response in opposition to defendant Williams' motion to challenge factual findings. Following a recusal of Chief Judge Glanville. Hold on. I got to back out. Following a recusal of Chief Judge Glanville, participated by motions from defendants Kendrick and Williams, defendant Williams had filed a motion to challenge the factual findings made by Judge Krause in her order recusing Judge Glanville. For this reason cited below, the state respectfully moves this court to deny the relief defendant Williams' motion request in support of this motion. The state shows this honorable court as follows. Background. Defendant Kendrick and Williams each filed motions to recuse Chief Judge Glanville from this case. In support of their motions, each defendant submitted an affidavit or affidavits. The recusal motion was assigned to Judge Rachel Krause on July 17, 2024. Judge Krause ruled on the motions and entered an order containing written findings of facts and conclusions, as required by Uniform Superior Court 25.6, hereinafter Rule 25.6. Legal authority and application of law by Judge Krause. Rule 25.6 governs the requirements for recusal orders, and the rule grants to the judge considering a motion to recuse discretion to either rule on the motion considering solely the affidavit or affidavits, or to convene an evidentiary hearing. Rule 25.6 requires that the judge, considering the motion to recuse, rule on the merits of the motions and make written findings and conclusions. Judge Krause considered the motions to recuse solely on the affidavits submitted by the defendants. And as required by law, Judge Krause included in her recusal order written findings of facts and conclusions as mandated by Rule 25.6. Even when a motion to recuse has no merit, if a judge is perceived as refuting a charge of bias, the judge's actions create a basis for recusal. Judge Krause wrote that in transferring the cases to another judge for consideration, Judge Glanville necessarily determined that recusal might be authorized if the facts alleged in the motion were assumed true, and Judge Glanville was prohibited from opposing the motion. Judge Krause agreed generally with Judge Glanville's assessment of the propriety of the ex parte meeting but found that Judge Glanville created a basis for his recusal when he added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Judge Krause found that in presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegation, mandating his recusal. Lack of authority for Williams' motion. Defendant Williams asserts in his filing that Judge Krause made two findings that are erroneous in her order recusing Chief Judge Glanville. Footnote 1, see Isaac v. State, stating we recognize that judges may be sorely tempted to respond to motions to recuse, which they perceive to be gracious defamatory. We also recognize that a judge who actively resists recusal may be fully capable of even-handedly presiding in the motion is denied. Nevertheless, we think that these factors are heavily outweighed by the necessity of preserving the public's confidence in the judicial system. We therefore hold that after a legally sufficient motion to recuse has been assigned for hearing, the judge against whom the motion is directed may not oppose the motion.
So legally sufficient motion. Okay, go ahead.
First, Defendant Williams objects to the order's reference to his recusal motion's inclusion of hyperbole. The reference to hyperbole is accurate. Most importantly, the reference to hyperbole is not itself a factual finding and is not a material issue for litigation. Second, Defendant Williams asserts that Judge Krause finding that the hearing in chambers was not improper is wholly against the law. The assertion is clearly incorrect. The hearing in chambers was regarding a witness's immunity and compelled testimony. Such a hearing without the defense present has been held to be proper by the Supreme Court of Georgia, which ruled this defense has no standing to be present at such hearings. Conclusion. For the reasons stated above, the state moves this honorable court to deny defendant Jeffrey Williams' motion to challenge factual findings. Respectfully submitted this 23rd day of July, 2024, Adrian L. Love. And then there's a footnote 2. It says Williams' motion to recuse. Third footnote, she did some case citing, Allen v. State, King v. State, an authority for its ruling the appellant had no standing to contest the grant to use immunity to a witness. Also, see also King v. State, overruled on unrelated part by Clark v. State, in ruling after appellant complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derogative use immunity that would apply to all compelled testimony, that the hearing in question was not in part of the proceedings against appellant, and while appellant might have preferred that a key witness was not to be ordered to testify truthfully in his trial. There is nothing in Georgia law that have permitted him to object to the state's request for the order that would suggest that appellant's rights were the subject matter under consideration, and appellant has no standing to address the matter of the hearing outside of his presence.
Listen to this. She used the thing incorrectly because she forgot he was a sworn witness.
Correct.
That's the part she's forgetting. They're not saying it's bad for them to get the immunity. They're not saying that. It's bad because he was a sworn witness.
In Clark v. State, it is a way different circumstance.
When you want to break it down to the people, what the circumstance was?
Yeah, I'm pulling it up now for him.
Okay. She's breaking it down for you guys what Clark's reasoning was that.
Yeah, Sylvia. I don't think she forgot. She just omitted.
I'm with you, AJ.
Maybe she forgot. Give her the benefit of the doubt, y'all. Maybe she forgot. Give her forget. Give her benefit of the doubt. Maybe she forgot. Give her benefit of the doubt. You lie by omission.
What people start doing when they get scared, Miss Sylvia?
What do the people do when they start getting scared?
Yeah.
Forget. Ah, Jason says Sylvia with her hug back. You know what? You out of order, Jason. Jason. Jason, you were out of order for that.
Miss Sylvia, do you think that the district attorney and them is?
You sound like you're in the closet. Are you in the closet?
No, I'm not on Kelly. No, not today.
No, you're in the closet. You sound like you muffled. I didn't hear everything you just said. Say it again.
I said, do you feel though that the state has a case?
Has a what?
Has a case.
A case of what?
Reasonable doubt of their findings.
This whole case is a reasonable doubt.
No, do you?
I just told you. What is this? You need to get out that closet because something must be fogging your brain because I've been saying that from the beginning. I mean, not beginning, since this has been going on. I said there is some doubts.
Do you think that she'll be their downfall of them?
Don't ask me those type of question, please. I plead the fifth. I'm not answering that.
Okay.
Look.
Mm-hmm.
I am just, let me put my disclaimer up. Hold on. I got to put my disclaimer up. I forgot to put my disclaimer up. Here's my disclaimer. Okay, disclaimer. As a professional blogger, my role is to deliver news and information from all sides of an issue. The content shared in this channel represents factual reporting to the best of my ability. Okay? All right.
AJ, what you think, AJ?
Do I think that say it again?
Do you think that she has any findings?
Nah, man. I mean, she's been grasping at straw. Somebody needs to check on her shoulders because she's reaching, bro.
She's playing rock, paper, scissors.
Yeah, man.
Hey, we have a new guest on the live. Hello, Mr. Jones.
How you doing, Miss Sylvia?
I'm fine. How are you? I'm glad you're up here.
Yeah, I had to come up. I see what's going on in the state of Georgia. I'm here from Indianapolis.
What's your thought on everything?
Yeah. Mistrial with prejudice. The prosecutorial and judicial misconduct is barred by jeopardy to retry that. There's no way they can retry that. ADA Love. I'm listening to her notice. What was the purpose of a notice if she wasn't trying to, excuse me, if she wasn't trying to, I think she was hinting at something to Judge Whitaker. I think she wants her off the case because she knows she won't be able to get off what she got off with Glanville. So I heard somebody calling YSL Glanville. The state's in trouble. The state is in trouble. I don't see, there's no way if a mistrial is granted that it can be without prejudice. It has to be with prejudice from the ex parte meeting itself. And what I don't hear a lot of people talk about is even before this, when we go back to opening statements, was she burden shifted? that was a mistrial there, and Judge Glanville didn't grant it, and he should have. So the jury was tainted from opening statements. I think heads are going to roll after this case is over with. Them using Lil Woody as their star witness backfired. Totally backfired. And if you remember in the ex parte meeting when Woody and Hilton was going back and forth, he kept telling her, "I told you that I was lying on them boys," and she said, "No, you told me you are a liar." She was trying to cover herself because I believe everything he said in that ex parte meeting. He told her that. And here's another question I have. Why, when the ex parte meeting started, Love was in there, not Hilton? And then when they bring Woody in, here comes Hilton, and then Love disappears? What was the purpose of that?
Interesting.
So she can get off the record.
Right.
But she was already on the record.
Not with Woody present.
I think what it was, and I seen something where she had prosecuted a case where was it somebody in Lil Woody's family, his brother or somebody was murdered, and she botched that case?
I would like to know more about that case.
Yeah, it was somebody. Was it his brother? It was a family member or something of Lil Woody's, and that's why Hilton did the examination and not her. But I also think this is why I say they knew Woody was going to plead the fifth. Love didn't want to be a part of that because he told them before, "I'm not testifying, I'm pleading the fifth." And they basically forced use immunity on him and lied to him because this is a state RICO. The state can't speak for the federal feds, and the feds can't speak for the state. So how can they tell him that the feds can't prosecute him? Because
Right. That would be a second immunity. It's a whole separate form that he would have had to have signed. And you can't have forced immunity with the federal.
Exactly.
You either
I always ask
cooperate.
that question if you have been coerced into testifying today. That's one of the things they do ask in the Fed.
But for DA Love, that is accurate. She had prosecuted one of Woody's family members, so they could not have her do any of the cross-examination on Woody for conflict of interest. But she still dealt with him in the chambers, which she shouldn't have been a part of.
Right. I don't think she prosecuted a family member. I think one of his family members was unalived. And she was the prosecutor on the case of the person who murdered his family member. And she botched that case.
Oh, so they got away with it. That's basically what you're saying.
Yes.
Oh, okay.
Oh, so she got a history of botching cases. Okay.
Well, the case that she cited, Georgia versus Clark, was probably the very wrong one to cite on there, because that case had a lot of issues and went to the Supreme Court. This case was filed in North District of Georgia. It involves a petition for removal, a suit against a federal officer. They have concealed information. The case was filed August 21st of 2023, terminated on September 29th, 2023. And the last known filing date was November 9th, 2023. So they were trying to bring it back up. The Georgia Supreme Court vacated the trials court's judgment and remanded it was for an evidentiary hearing to determine whether plea counsel's ineffective assistance was responsible for Clark's failure to pursue a timely appeal. And also appealing in convictions challenging the evidence presented at trial, the admission of an audio recording and the jury instructions. His trial counsel was also accused of providing ineffective assistance. So definitely citing that one, and it's wrongdoing on the state is probably not a good one to cite in a motion. And it's actually it's open on appeal after it was thrown out. So it looks like they tried to refile in November.
So it has no decision. Did you see your opinion on that one?
So I got the original document.
Mm-hmm.
After Supreme Court vacated it, it looks like they went ahead and did appeal to that in November. It has not been heard. So citing that one, it's at Supreme Court, and the judge in Supreme Court had already ruled that it was vacated due to the inassistance and what occurred on the state's behalf. So that's not a good one to cite in there. Is there another one that was cited?
Let's see. Hold on.
I would have probably stayed as far away from that one as possible.
She did Allen versus State. She did Clark. You just read the Clark one, right? So Allen versus State, and there's King versus State. Allen versus State and King versus State.
Well, Allen versus State was a reversal on conviction of the plaintiff in error for a murder. That was a writ of error.
What about King versus State? And that's a 2000.
You said King versus State?
Yeah, that's 273 Georgia 258 264 265 2000.
Removing a significant legal barrier. That's for voting.
Oh well, there it is.
Yeah, that's a 2000. The Supreme Court actually put an order in for that one in October 2nd of 2000.
Okay, Prentice, can you please explain, because the people in the chat are saying that they thought it was a case against Kenneth's brother and not the way you saying it.
Which one is it?
This is regarding.
If I'm not mistaken, it was a case against somebody else who done something to one of his family members, I believe. I could be wrong, but I'm quite sure I read it when I heard it. They said that she was the prosecutor prosecuting someone who murdered someone in Woody's family, and she botched that trial. So
it was the opposite, because they touched on it in court, Sylvia, on why she would not be cross-examining him.
Do you remember when they talk about it, y'all? Do y'all remember which part they were talking about? I could play it.
Let me pull it up. Let me dig. One moment.
I stand corrected. I thought it was the other way around. Pardon me. Don't kill me, chat.
You know they be coming after you because they be on it.
Yeah, But here's something. I'll go back a little bit. If Glanville and the DAs knew the ex parte was legal, why did the judge get so heated when Steele wouldn't snitch on the mole? If you did nothing wrong, there's nothing to get mad about.
Blind man can see that, bro.
Exactly. That's what I'm saying. So even her response, and I say that to say this, even her responses to Steele's motions, they lack substance, first of all.
Say it again.
And she has no legs to stand on. I think I heard Kat No Williams, because I watched her live a little right before I came in.
Mm-hmm.
And I think somebody said something to the effect of she was just blowing steam. She had no argument. She cited minimal case law. And that's where really judges make their rulings. When you cite case law and can back it, she has absolutely nothing. And I've been watching the trial, and I've seen that in a lot of her motions or responses. She never cites accurate case law.
She don't. If you've
She
been
doesn't.
watching, you see that. She always changes the point, kind of like with her motions.
Yeah, she doesn't want to. She doesn't want to. If she bows down and don't say nothing, it's like, okay, well, it's letting the defense basically win and overreach. It's like someone getting the last say so. Being nobody that is her case, well, their case per se. Okay, it's like, all right, I want to get the last say so. Okay, all of these motions that she put in here, this is justifiable means for something else. I guarantee, mark my words, she's not going to do anything about the recusal of herself, okay, or put anything in until I think they got up into Friday to get all of this stuff in. So she's probably going to do it tomorrow. Miss Sylvia, I think Friday is like the last day, correct?
Yeah. Mm-hmm.
So
Well,
if she doesn't do it tomorrow, she will do it Friday. So right now, she's just throwing cases out here and just putting some stuff in here just to say, okay, well, I'm just replying to the motions. She know it doesn't have no argument, no leniency. So that's what we're going to continue to keep doing. We're going to constantly keep saying the pettiness. You know,
I think. Oh, sorry. Apologize.
Go ahead.
I'm willing to make a friendly bet that she's probably going to ask for an extension.
And I hope they don't give it to her.
And I'm willing to bet that Judge Whitaker will deny it.
And I'm thinking, I'm with you, Mr. Jones, but I'm with AJ too. I think she's gonna deny it because this judge is not playing. We got two judges that has been saying publicly now on live TV that this case is entirely taking too long. I like the fact that the judge told them, listen, I need to know what they gonna be testifying to because I got a law that says I can basically go something for a lot of us know that a lot of the stuff is computer. They got the cab lady report. She about to come back again. For what? To tell us the same old thing? Because they don't want to get rid of her? So, yeah.
Okay, guys. I see a couple of people, GM, and I see GM and I see Pete in the chat. One of you guys need to come on up because we need to hear other sides of this too, because we don't want people to say, oh, she's only one-sided. I want to hear what you guys got to say on the other side. Y'all talking to each other. None of y'all coming up here to give me your input. I want to hear what you guys got to say because I see GM mentioned that it was not a secret because it was on record.
It was on record after the fact.
What was?
The ex parte hearing.
Oh, got it.
Can I respond to what you just said, Miss Sylvia?
Yeah, go ahead.
Even though it was on record, none of the defense counsel was made aware of it. So it is a secret.
And to your last point, the other guy got so upset that the defense found out. So he confirmed the said secret.
That was a
meeting.
secret, yeah. Because he did get upset at it. He was like, where did you get that from? The only person that should have known, and if that means somebody might have recorded, and if you was eavesdropping, he's made a lot of comments about it. So
And how is it ex parte when you have security and all of those other people outside of counsel in there? Everybody was in their chambers except defense counsel. Everybody was knew about it except defense counsel. So what's not secretive about that? We're going to keep it away from the defendants.
And they knew they was in the chamber. They knew they was in the courtroom for an hour and a half without them. We were waiting on them all morning. Like,
Even Kayla Bumpus said, she said when she got to the courthouse, she went in the courtroom and they came and got her and pulled her into it. So she wasn't even aware of the ex parte until they came into the courtroom and got her.
correct. It's because of what they were saying inside of said meeting.
Right.
They
So
keep trying to make it a point about the meeting. Nah, man, it's about what y'all had going on inside of it.
exactly, and still made that point. He said it's about the substance, and Glanville didn't want to hear that about substance. No, who
No.
told you?
He said, who told you? He said, you should have told me.
Right, 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 and
And that's when he got mad.
Yeah, that's when he got mad. So I'm going to give you 5 minutes. I don't
Yeah.
need 5 minutes.
You saw Glanville bull. His whole face looked like it just blew
Yeah,
up.
I bet Jack was back there tripping like, bruh.
I'm gonna tell y'all something funny. I don't know if y'all caught it. Um, when Glanville told Steele, uh, we're gonna have some problems. Steele started to say, but he caught himself. Did you hear what he said? We can have all the. Then he stopped. He said, "I have a problem."
Yeah.
He was he was about to tell him, "We can have all the problems you want," but he
Yep.
caught himself.
The
Did y'all
people not
notice
coming up
that?
still?
huh?
The people not coming up?
I don't want too many people up here at the same time.
Oh, well, all you had to say was leave, AJ. I'll leave.
I wasn't because it becomes chaotic. So I just want a few at a time. So once a you group get up, and then I'll put it out again. He jumped up. All right, go ahead, Prentice.
Yeah. So I thought that was interesting because still he caught himself at the last minute when he said, "Well, you're gonna have a problem." And he said, "Well, we can have all the," and he stopped himself. He kept it professional. I thought that was kind of funny. I wish he would have just said it.
Yeah.
Yeah, but this I don't see how in the world this even became a case. I've seen nothing. And what's funny, nothing they say implicate um young Thug. Listen to all the testimony. You know, they're really not. There's been nothing to say Young Thug did anything from Lil Wayne's bus shooting all the way up into Nuts murder. Thug, Thug isn't implicated. I guess they're just saying he's the ringleader. He's giving directions. This man was on tour. I'm on tour. I'm trying to make money. I'm not concerned about what nobody else is doing. And I really don't think YSL had anything to do with Nuts' murder. Because if you remember when they showed the video of the shooting and they showed the picture in the barbershop, remember they showed Nuts' brother in there with an AR 15, but that AR 15 has never been recovered. And they're saying he was shot with an AR 15.
Yeah.
Why didn't they recover that gun from his brother?
Okay.
Yeah, that seems a little fishy. I think the whole investigation was botched. Faulty police investigator and detective work. Faulty, in my opinion.
So the news, one of the world news, they released a banner for the YSL trial yesterday. They put young thugs succeeded through music, not crime.
Right. And everything I've ever heard, I heard like if people did something, he kicked them off his tour. That doesn't sound like somebody who's committing crime or um, giving orders to commit a crime. He's trying to get away from it. Even even in the pretrial hearings, remember when they had the little 15-year-old kid come up? The judge didn't even want to let that kid testify on Thug's behalf because these are character witnesses. And I think that might have been a bond hearing. The judge, Glanville, didn't even want to allow that kid to testify on Thug's behalf. The fix was in from the beginning.
Hey, Shell, what's going on? How are you? So her phone messed up.
She didn't want to talk to you, Miss Sylvia.
She hung up.
Yeah,
Okay.
she didn't want to talk to you.
Okay.
Miss Sylvia, I also seen something yesterday that Love found that had something to do with you. Not
Yeah,
wanting.
it was the interview I had with Adams.
Right, that was it.
Yeah. Hey, Shell. She's
Hey,
back.
sorry.
She's like, he said you don't want to talk to me.
Oh no, of course I want to talk to you. I just wanted to because I know we were reading the motion or the motions, the filings, the notices, the waste of paper that Love sent. So I just wanted to give my 2 cents about that. About that. So I think that I think the main issue with her, what was the last one called? Not the notice, but the other one was that wasn't a response, was it?
One of them was. The second one was a
Okay.
response to Steele's motion regarding Judge Cross.
Yeah,
Mhm.
regarding her findings or his factual findings or something like
Yeah.
that.
Mhm.
So the one thing that I had issue with Judge Cross's motions, because at the end of the day, our ruling, at the end of the day, I think we all got the result that we wanted. But of course, there was a whole bunch of outs, in my opinion. She wanted to get to the end goal, but she didn't want to throw the DA or the judge under the bus. And to me, she gave them an out, and that is exactly where Love pretty much rode on. She just stuck to, like, oh, it was the public's opinion, and it was because he explained his order, which is the reasons why he's out, not because of our ex parte meeting, not because we've been shady and all of the things um, that Steele mentioned. So she relied on that in her response. But I think that our new judge is wiser. She knows what that judge did, and she knows that the meeting was improper. In my opinion, I believe that she knows that that meeting was improper. Anybody knows that. We with no law degree know that. That there were so many, violations in the defendant's rights that occurred during that meeting. So, I mean, but what else could she do to like rebut it? Like she really didn't have much to say. Still stated facts, and all she could rely on was the facts that Cross made in her motion or in her ruling. So, I mean, we couldn't expect anything more from Love, but to ride on the coattails that Cross, laid out for her. Cruz Cross, I'm not sure how we say her name. So that's how I feel about that. And that other waste of paper,
You
mute.
on it today with the waste of paper.
That was moot. What did they say? Moot. That was moot. Like, why bring it up if you're not going to state the whole facts? Tell the truth, the whole truth, and nothing but the truth. She's going to omit the part about Glanville's findings. She didn't put that in, trying to recuse him. So why bring it up now? Like, girl, stop reaching. So those are my opinions about our 2 readings for the day.
Thank you. I've been trying to get somebody who does not, who's on the other side to come up and say something, and they seem like they scared.
Miss
Come on
Sylvia,
now. Come on up, huh?
I don't think, looking at the facts of this case, there is another side.
GM and I saw GM and somebody else. It's 2 people. GM and I think Nick, was his name Nick? They're in the chat saying some stuff, and I want them to come up and I want to hear from them for real. I do. Because I don't want it to be one-sided. I want both sides to give their opinion, because their opinion matters. Pete, why don't you come on up, Pete? Come on up. GM or Pete, one of y'all, come on up, because you have some strong opinion. And where's Rob? Robert, what's his name? Hart? I need some opposing side people to come on up. Because some of them was mentioning stuff regarding love, motion, and things like that. I want to hear from them. I really do, because typing sometimes we can't get the full understanding of what you guys are thinking. Because I really, really would like to hear what they're saying and why they believe what they believe.
Yeah, I mean, everybody's opinion is important.
Yeah.
And like I said, opinions can be argued, facts can't be argued.
That's true. Thank you for mentioning it, Roll Up One, because I have the letter. I have the letter that Bonnie sent in regard to Lucci for him to be out. So did you guys wanted to see that letter?
Yes, I was actually just going to tell you right now if we could actually get that pulled up, because
I got it.
It is vouching.
I got it, y'all. I got the letter. Y'all know I got it for y'all. And 2 head, 2 leg, 2 nose gonna read it for us.
I'm gonna get you later. I ain't had no sugar in a couple days. I ain't gonna do it right now.
So Miss Sylvia, you got you a paralegal, huh?
Yeah, finally, right?
She fine.
Okay, hold on. Let me get it to her. Yeah. All right, you should have it right now, and I'm gonna put it up for the people. You got it?
Refreshing now.
Okay. All
Nope.
right, guys.
Yep.
Hold on, y'all. Let me put it up for you guys.
Oh, that's small. I have to zoom. Hold on.
You guys can see this?
Yes.
Hold on. I'm gonna have to zoom a little bit.
Thank you so much. I'm starting to get cataracts in my old age.
Don't claim that. Don't claim that. Look, I forgot we can't say I rebuke that, because you never know what could happen if we say rebuke in Jesus' name.
Oh, yeah. No. I'm not one of those. You can rebuke it.
No. You see what happened to that lady, right? When she rebuked the lady with the police officer doing all that extra stuff. She said, I rebuke you in the name of Jesus, when he said about the water, throwing the water.
No, I didn't see
Made
that.
those. Oh, y'all didn't see that? Oh Lord, they've been all over the place with that.
Wow, I didn't see that.
Hmm.
Ready?
Yes, ma'am.
All right. Office of the Fulton County District Attorney, Atlanta Judicial Circuit, from the desk of Bonnie Willis. State Board of Pardons and Paroles. 2, reason the state's position concerning Rayshawn Bennett's parole eligibility. Dear board members, pursuant to the parties' negotiated agreement, the state does not object to defendant Rayshawn Bennett being released from Department of Corrections the first time he becomes eligible for parole or after serving 1/3 of his prison sentence, whichever comes first. This recommendation by the state is conditioned upon the defendant's compliance with the lawful authority of all Department of Corrections personnel and having no incidents of any kind in any facility in which he has been housed while in the custody of the Department of Corrections. Attached to this letter is a file stamped copy of the defendant's final deposition. Should any of the board members have questions regarding the state's recommendation, please feel free to contact my office anytime. Respectfully submitted, Fonnie T. Willis. I just want to add real quick, there's a good part right here, that says that he has defendants compliant with the lawful authority of all Department of Corrections personnel and having no incidents of any kind in any facility in which he was housed. Remember, he's been stabbed in there and he's had some issues in there that his attorney brought out, and that was a public hearing about the issues he was having in there. So all that doesn't count, and they put it under gang related for the stabbing. But it says no incidents.
Wow. So she's advocating for Lucci to be released early. But on the same token, what the young people call his ops are on trial and she's trying to bury them. Sounds like she has a vested interest with YFN. And because they were at odds with YSL, she's trying to get them released and trying to get YSL thrown under the jail.
Well, I mean, to put that there's no incidents, I mean, that's not facts. His incidents were actually public. The hearing is public. The articles are public. And also the report that they filed within the Department of Corrections is public access as well. So I don't know if she knew that the letter was going to get out or whatever, but this makes zero sense.
Now, how did she become the DA of Fulton County again? Because she knows that if it's public record, he was stabbed and had incidents. How can you say there was no incidents? She has to know that.
Oh, well, yeah, she knows about that case is held within her courthouse that she's in. And
So
his attorney had came forward and said, there was safety issues. He had been stabbed, that there was a gang war in there, and that removing him from that jail, that's what they were trying to get at that time. That's when they gave the ankle monitor to go home.
So that was a blatant false statement that she just made then, correct?
Is and was.
Yeah. Yeah. A lot going on in Fulton County.
But see, you're vouching for one that has all of this stuff and a felon, was already on parole, and then you have another one that's not even a felon and
Right.
doesn't have the same.
Right. I was just about to ask that question. If I heard correct, Young Thug doesn't have any felony convictions, correct?
No, he is not a felon.
No.
But he was unable to get a bond.
Yep.
Wow. Yeah. That sounds like something personal. And I heard somewhere that I read on one of these podcasts that she allegedly had a relationship or relations with either, what is it, a guy named Mondo or even Nut.
We don't know that for a fact, guys. So I
Right,
don't like.
that's why I said allegedly. That's exactly why I said allegedly. But the way it's looking after just hearing what was read, it sounds like she has some type of vested interest. So, Miss Sylvia, and two minds, one mic. Ask you guys, what do you all think is going to be the outcome once these hearings to all these motions are held?
What was, say that again?
What do you feel like the outcome of this YSL trial is going to be once the oral arguments are held? How do you think, just your opinion, I know nobody knows what the judge is going to do, but in your opinion, what do you think the end result is going to be?
I really don't know. Really don't know. I really don't know.
Because in my opinion, and like I said, this is just opinion, I don't see no way you can bring that jury back in, because there's absolutely no way that at least some of those jurors have not seen what's been going on. It's all over social media, all over the news, it's over everything. The only way they don't see it is if they don't watch TV, their phones are powered down. It's absolutely impossible for them not to see something. How can you move forward with the jury that we know, even if they don't admit it? How do you move forward with that trial? Because
Well,
the jury,
they're gonna have to poll the jury when they come back. They're gonna have to poll them because they've been gone long enough. But I don't know if they will. But they're gonna have to. If the defense asks for the jury to get polled, they probably will be polled, or even if they're state,
because the last day the jury was in court, if I'm not mistaken, was June 17th, correct?
Mm-hmm.
So we're
Yeah.
talking a month and a half.
Mm-hmm.
Are they still being paid?
No, they stopped being paid as of right before the holiday. I'm talking about the 4th of July. Because remember,
Okay.
he had given them administrative leave. I mean, the administrative day. He okayed them to get paid for administrative day, but all the other stuff hasn't been administrative day. These have been days that with all this craziness going on.
So were they allowed to go back to to their regular jobs? Probably not,
I don't know. I don't know.
because if they were, those who have jobs or careers, I'm absolutely, I'm willing to bet that some of their coworkers have informed them about some things if they haven't seen it, or were asking, inquiring about some of the things that was going on, even if they hadn't saw it. If they went back to work or whatever, people, that's just the nature of people. If they know they're on the jury, they're going to ask questions, or inquire, or inform them of things that they might not have seen.
Mm-hmm.
I I can't see how you can bring a jury back. That's why I say this has to be a mistrial, just based on the law. Just based on the law. There's I don't see no way. And I also believe that for this reason. Remember when Judge Whitaker was encouraging uh, the state and defense to perhaps try to come up with a plea?
Mm-hmm.
She didn't just throw that out of thin air, because she sounds like she's going to follow the law. And if she follows the law, this is guaranteed a mistrial with prejudice. So I think what she's trying to do is save the DA. But I don't think none of the defendants are willing to take a plea bargain at this point, because Max Sharp said itself, and I believe Weinstein said they believe they're winning the case. And somebody who's watching this trial, they're no doubt winning this case. So I think she's trying to save the DA some embarrassment by asking them that, hey, I'm willing to listen if you come up with a plea. I think that was more for the DA than it was the defense, to save them some embarrassment.
But their plea deals aren't plea deals. It's like, okay, go do 25.
You have John Yazell says the state is very much winning this case and the jury sees the evidence loudly. John, come on up. I don't know what case he's been watching, but
Yeah, I respectfully, I totally disagree. I mean, but that's his opinion.
now I want to see. I want to know why does he see that that the state is winning? I want to know, what is he seeing that we don't know? He's being sarcastic. Okay, that's what Melanie said. Melanie said he's being sarcastic. Okay.
No, there was several comments in there from him where, it's good to hear both opinions. I think when several people come out strong and they have an opposite opinion, it might, detour them from coming up to speak their side. But it's good to have both sides, because it's something that you may have or you may see to believe that they are ahead. So what is your mindset? If you don't want to come up, put it in the comment.
Yeah, he says, he's not being sarcastic, but from what I see, the case is strong. What have you seen? Because is it from the witness standpoint? Have you seen the evidence? I mean, I'm not trying to be funny, but I just want to see. What have you seen? Because you have a case where most of their witnesses have been perjury. I mean, they have
impeached.
They have impeached them. Thank you. I was trying to figure out the word. What case have you ever seen where a majority of their main witnesses have been impeached?
And they're your witnesses, they're not the defense witnesses, they're your own witnesses, which tells me they were very unprepared. Every witness that I saw, even the investigators who got up there on cross-examination, they got caught in lies. That's
I think John is being funny. I think he is being funny because
I don't know. I mean, there's a saying, two people can look at the same exact thing and see something totally different.
okay. He says here, hold on. He says, yes, ex-gang members, and yes, I agree, unprepared. However, they were scared. Who was scared? They have not even proven anybody was scared. They haven't even proven that.
The only thing I remember was when was the guy get up and he went off on the DA when he told him, y'all just put my address and phone number or my phone number for the public to see. He was getting calls, but that doesn't necessarily have nothing to do with YSL.
That's true.
That doesn't. I mean, because you have fans, and fans is short for fanatics, and you have people that are fanatic about something. Fans do crazy things too.
All right. Mama is saying drop the link, but Cavell, you could have put the link in there. Come on now, dude. Do some work. He's saying drop the link and he could just copy and that's what mods do. Copy and paste. True. Okay, hey Cavell. Oh, there you go. Cavell, you out of order. Hey, good morning.
No,
Good
I
afternoon.
just wanted to say, Sylvia, that guy is a troll.
I can't hear you. You mute muffled.
He said that guy is a troll.
Oh, he is? Okay.
He been doing this since Law and Crime with every channel.
I cannot hear you. Can y'all hear him?
Yeah, he said he did it on Law and Crime and everything. So I guess that's what they call devil's advocate.
Okay.
No, I was saying that he does this in every chat. He goes against the majority of people's opinions and he just says stupid stuff.
Oh, okay.
He can't say it, and he can't say the things that he normally say in Fox chat, which would be vulgar things. So he know he's going to get kicked out of here. So he's just going with saying
Yeah,
stuff
because
about
we don't
stuff.
do the vulgar stuff here.
Yeah. He's the real troll. He's been doing this from Law and Crime, Sylvia. I know that person following the crowd. That's what
Okay.
he do.
Okay.
Don't entertain him, please.
Thank you. Thank you for that. I appreciate it.
Yeah, you get a lot of trolls. You get a lot of trolls. But yeah, I don't see anything that remotely looks like a RICO charge against none of those defendants.
Yeah. You know what we're going to do? Since somebody talked about her opening argument, we're going to go ahead and play Love's opening argument so you guys can add like a reminder what she had said. So hold on a second. Prosecutor's opening argument. Here we go.
Can we watch the movie Jungle Book?
Ma'am, no.
She mentioned Jungle Book, Miss Sylvia.
We're not going to watch Jungle Book. What? Y'all. Exactly. You know what? No, man. I'm gonna say Nardo, man. Listen, you're right. What is the definition of troll? Please, somebody, please help me with that. What is the definition of troll?
In lay terms, it's just somebody who goes against the majority for argument's sake.
Oh, okay.
That's why I used the term devil's advocate a couple minutes ago.
The exact term is a person who posts deliberately offensive or provocative messages online or who performs similar behaviors in real life. The method.
One more time. Say it one more time.
Let me open it up all the way
For
for you.
those, because I thank you for asking that
It,
question. I really didn't know what trolling mean.
it says a troll is a person who posts deliberately offensive or provocative messages online, such as social media, news groups, forums, chat rooms, online video games, or who perform similar behaviors in real life. The methods and motivations of trolls can range from benign to sadistic. These messages can be inflammatory, insincere, digressive, extraneous, or off topic, and may have the intent of provoking others into displaying emotional responses or manipulating other perceptions or acting as a bully.
Okay. Thank you. Thank you. And that was definitely because I really didn't know what troll was. I heard people say it. I asked before, and people say, "Oh, they're trolling." So I was like, "Okay, so what is?" Okay, but I understand it now. Thank you.
She on point. You got a great paralegal, Miss Sylvia. Like she had it open when you asked.
Okay, thank you. You guys, a whole bunch of y'all probably wanted to know what that meant too, right? Only person who was brave enough to ask is Nato. Man, thank you for asking that question. No question is a stupid question, especially if a lot of us don't know what it is. I'm gonna admit I did not know what it was. So thank you guys. Thank you. 2 head, 2 hand, 2 legs, 2 feet.
That's a lot of names, Miss Sylvia.
I'm going to get her. Don't even worry. Don't even worry. After I get a little breakfast.
All right, let me go ahead and play this, y'all, so we can get to hear. Thanks for reading where we can Google. Oh, Michelle, that was mean. But I needed that because I wasn't gonna Google. Y'all like to y'all just some mean folks up in here. Y'all, and then y'all get mad when I be going in on people. Oh, I know y'all better not ever come back to me and say anything like that.
Miss Sylvia, you being trolled. She just read the definition to you.
Well, you want it right out of textbook. You got to get it from the dictionary. Just say something out. The back end ain't gonna work.
They just being mean up in here. Y'all be hating on my help. Y'all just.
I don't think it was smart, but she's just saying, thanks for doing it. Everybody didn't have to Google. That's how I looked at it. I don't think she's trolling.
Oh, okay. Yeah, okay. I got you.
So you got a different definition from me. Okay, thank you. I guess everybody says things. When you're reading stuff, I read the. Oh, she said thank you. Okay. That was me misinterpreting. Because when I see somebody else laughing behind the statement,
I didn't read it like that. I read it as the first word was thanks. You read something that we all could have Googled. So I took it as she's like, thanks for saving us the time, not having to go do it.
But then Marley laughs. So I'm thinking, okay, why is she laughing? Because, Marley be laughing. Those two be like tag teaming folks. I be seeing it. So I was like, okay, what is Marley laughing for? Okay, my bad. I misunderstood.
I did too, because I didn't.
You thought the same way I did too. Okay, I know I ain't crazy.
No, I did too, because I didn't hear when she said thanks.
I didn't see it either. But okay.
It was the first word.
BG said that's no sugar. That's me, BG. That's no sugar.
BG, same. I'm same.
I stand corrected, ma'am. I apologize to you. You wasn't trolling.
I apologize. I was on another. Okay, here we go. How many motion was filed yesterday? What was our total yesterday? 9? Well, if you count these 2 that she put in, so that's 10. 10.
No, there's 11.
Well, we have 11. We're not going to count the response. We're only counting the motions, right? So it's 10.
So it's 10. That was my number. I won. Who gonna pay me?
Who else? No, somebody else had 10. Who else had 10?
I got a list. I'll go get it downstairs. I put the list yesterday of everybody who participated.
It was 10. It was 10, y'all. Not 11, 10. Motions. 10.
I think, Miss Sylvia, was it you that had the poll up saying how many motions would be filed? Somebody had that on their page, and I said 13.
Somebody had 10. Somebody actually had 10.
It was me. It was me. I had 10 and another person had 10. I have the list. I'll get it after you play it. I'll grab it in a minute.
Somebody said 10 because I said, oh, they saying 10 because I said 6 and then they add 4. I said that's 10. Somebody, I got to go back and review it because somebody said 10. You lose. No, it was somebody because they said it. They said it, and I said, "Oh, they saying."
Wait, Sylvia, a message just came through, and I wanted to tell you I didn't get it either. They said they didn't get your alert that you went live, and your alerts did not come out today.
Oh wow, maybe because I did it live already.
You know what, Miss Sylvia? I always, when I'll see you, it says you have a live coming up, notify me. And every time I hit the notification button when you come live, not just you, but the lead or anybody, I never get the notification.
That's not good. They say sometimes you have to unsubscribe, subscribe. Somebody said they got the alert late. Can someone please answer my question, please? Okay. How is it not prosecutorial misconduct when the reason the judge was removed was a direct result of the action of the judge and prosecution? Good question. Show me the money.
It is prosecutorial misconduct, but the way Judge Krause formed it in her order, she's saying the ex parte, there was nothing wrong with it, which anybody with any kind of common sense know there was something wrong with that. She's saying the only problem was what he did after the meeting. So she totally ignored the actual illegal meeting. And I think that was to save face for the judge. It's definitely prosecutorial and judicial misconduct. But remember, on that Friday, the 7th of June, I heard ADA Love ask for an ex parte meeting, and Judge Glanville told her no. But then Monday morning, yeah, right then.
I saw the video, but I didn't see him say no. Okay, we're gonna listen to that part. Let's go. They said it go to 87, day 87. I'm gonna go to day 87, and we're gonna play that end part. And then I didn't know he said no.
And Judge Glanville also said that same day, after he held Woody in contempt, that we'll bring him back in court Monday morning. When Monday morning came, they didn't bring him in court. They took him in his chambers. But the question here's what I want to know. Before they brought Lil Woody in, what went on?
What do you mean? In the courtroom?
No, in his chambers. Before, we know at some point they started recording.
But I know for a fact, Hilton was not up there because I was downstairs and I saw Hilton go down to the courtroom on the other side because that's when I thought they were going to do the plea deal. And I mentioned then that Hilton was over there on the other side. So
Well, yeah, they said it. She wasn't in there, and that's why earlier, if you remember, I said, well, when they first started, Love was in there, but then when they brought Woody in, Love disappears and Hilton comes in. I think Love was trying to clear herself from any, because she knew it was wrong, and she was trying to distance herself from that.
All right, let me stop this one. We're gonna go ahead on and play the end of the day 87 when she was up there, Woody was testifying. Okay, hold on. No, he wasn't testifying. My bad. This is the day when they had the conversation.
I don't care. You can take my bar card.
Mr. Steele, I'm not trying. I'm not. Listen,
Wrong,
there,
though.
but there.
And Mr. Williams, to me, this is an innocent man. You talk about, Ms. Love said there's a man in the Fulton County Jail. He shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Ms. Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object
now
to the ad hominem attacks, and I ask
all because she wants to win a case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct. But and what I'm telling the court is what I said again. I do not appreciate it. And you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I object.
Try to silence me. I will not be silenced.
But Mr. Steele, here's the thing. Okay, I think that, Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Both, please be seated, sir. Sir, please be seated.
Whatever you do is fine, but I care about Jeffrey Williams.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that at times tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial, and so not only for the purposes of this, but it sends not the message I think you want it to send. All right, so I'm going to leave you all to your wise discretion in order to do that, but and I'll take up whatever I need to take up as I see fit. But I know that you all. This has been a long trial. It's very demanding, exacting, and grating on, and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see, and kind of look at, and just remember that you do represent of who you represent and what you're here for. In terms of the tape or the phone calls from Fayette County, it's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's what I mean. And Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence. And I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury, she's saying that that particular type of file has other things with it. I don't think you were given those. And that's what she's trying to get. So I'm in no way blaming anybody in this particular circumstance, but if you want that particular file, and I think you all should have that particular, the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all can, we can take that up, and it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. And remember, you're all going to see each other over and over and over again, and you know, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right. So I'm just going to recess, and we'll see where Mr. Melnick is at that point in time, and then we'll I can talk about Monday for certain. Okay. All right. Okay. I'm just going to recess in place. All right.
Miss Sylvia, I didn't see the part where she asked for the ex parte. She definitely asked for it.
Sorry.
Sylvia.
Did y'all hear that part? Sorry, I had to go downstairs for a second. I'm back.
And Sylvia, I didn't even hear the part where she asked for it, and she definitely asked for the ex parte.
Yeah.
She did say something at the end and just said, Judge, we may need to have an ex parte, but that was pertaining to the immunity. That's when she was trying to get the immunity.
No, they already had the immunity.
You already had the immunity.
It was the day Sylvia, look at the day before everything hit the fan, right before they dismissed for the day.
So
No.
that would be day 86.
That would have been Friday, because it's only Friday and Monday. There's only Friday and Monday. Friday's the 7th and Monday was the 10th.
That's right.
So that's a Friday then. We looked at just now as a Friday.
Go to the end. It was at end of day. End of day.
At the end of this, she said that Kim says the end of this video.
It was right when they was getting ready to leave court for the day before she pushed her chair out to get up.
The very end on Friday. 5:45. Hold on a second. She said 5:45. Hold on. Hold on. Oh, it's not finished yet. No, it's not finished yet, y'all. It's not finished. The video's still going. It's not done yet. You're on a break. Y'all made me stop it. You had me to stop it, ma'am.
Who did?
You said Sylvia. I said it
Oh, I
was over.
said it was at the very end of the day before she had pushed out her chair.
Present, so
Here it is. Hold on. Here
whether
it
or
is.
not he intends to do
It
that,
wasn't finished.
and we'll
Thank
see where we
you.
go from there.
Told me 5:45.
Okay? All right. Anything else? Okay. All right. Sir, enjoy your time off, okay? All right. Okay, council's anything else I need to cover with you before we recess until Monday?
Got it.
Yes, Mr. Botts? Mr. Botts, you need to use the microphone, sir.
Oh, there go that part, y'all. There go Bart's part.
Working now, can you hear me fine?
Yes, sir.
All right. Your Honor, we started this whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to?
You have to speak up, sir. And if you could hold the microphone, it'd probably be better.
That he was going to assert the Fifth. And I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. I even said the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine. I mean.
I got a problem with you now.
Well.
I would suggest you don't say any more.
I've already said it.
I know that, sir. And the problem is you should have told me if that were your case, then you just made an argument that was we didn't even need to have because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that.
And that's not what the point is. The point is you as an advocate is you should have told me. Both sides have an equal responsibility under the rules of professional responsibility.
Okay, as long as we're both responsible, that's fine.
All right, have a seat, sir. Thank you.
Is that okay?
No. What's your request, sir?
So in the attempt to avoid any spurious allegations moving forward, I would ask that Your Honor order that the deputies transport Mr. Copeland to the jail completely separate from any.
Yeah, thank you for reminding me of that. In our order, wait just 1 second. In the order of the incarceration, I'm going to, I also have a keep separate order for him.
Your Honor.
For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that they did.
I think that that's fair enough, and that's a good suggestion. All right.
We'll prepare.
Yes, Lieutenant Walker. So that will not be an issue? Okay. Okay. But we'll go ahead and have him, if you could also have him housed separately too? Okay. Okay. Thank you. Thank you, madam. All right. Anything else, councils? All right. Take a couple deep breaths this weekend, take a knee, and come back on Monday and let's get after it again, okay? All right. We'll see you on Monday morning at 8:30, okay?
Can you us the list of names and then any exhibits for Monday's?
I think the only, I don't know who is being called. We can find out. Ms. Love and Ms. Hilton and Mr. Atkins, who is going to be called? Let's assume that Mr. Copeland invokes again.
Your Honor,
Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So
Okay.
we
Fair enough.
we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay. Well, be thinking about what scenarios you'd like to have the court look at.
Yes, Your Honor.
Depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Sharp, he can have the floor.
Yes.
I'm just going to ask a courtesy of the deputies, could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to have a discussion with our clients.
Lieutenant Walker.
And Your Honor, the state has a matter we need to take up ex parte with the
Okay. All right. Lieutenant Walker has been asked by defense counsels.
He said okay for her to do the ex parte.
Yeah, I just heard, but he told somebody no to an ex parte. Or
You've been messing up today, sir. You've been
no.
You've been messing up today. Guys, those that have hit the like button, thank you so much for that. And those who have forgotten, could you please hit the like button? Those who don't want to hit the like button, okay. Thank you for your presence anyway. He said no to Kayla. No.
Okay. I stand corrected. I know he told somebody no, but yeah, he did say okay. But didn't the defense hear that?
We didn't hear it until now. I'm saying when we're in there, we didn't hear it. I didn't hear it until somebody had told me, and then I went and replayed it last week. But when I was in court, I didn't hear it.
Okay, see, watching it, I heard it as soon as she said it.
So I didn't hear it. I heard it when you guys, because when you're in there, you're engaged with other things in the courtroom. So
yeah.
You guys was sitting here listening. We were engaging in stuff that's going on inside. So I did not hear it when we were in there.
Right. So when it came up on the 10th and still said, he was unaware of it. And I was thinking to myself, well, she asked for it Friday, even though it was still illegal the way they did it. But I thought everybody heard her.
No, I didn't. I didn't hear it.
So they might not have heard her too, because they said it. We were unaware of it.
Yeah, I didn't hear it. But that don't mean anything. Right.
And she was away from the mic. She wasn't at the mic when she said it. She is she was scooted away from the mic. So
you know what? Let's go replay that one for a second. Guys, you know me, I like to go back and check things out. So if anybody have issues with it, okay, that's all right. But I'm going to go back 5 seconds and see what was going on, what other people was doing at the time. So maybe they were too busy doing other things to hear. You can't hear everything.
It said he told Melnick no when he asked to talk to him about his vacation time and being out of town and not making it in on Monday.
Okay. Thank you, madam.
Okay.
All right, anything else, counsels? All right. Take a couple deep breaths this weekend. Take a knee, and come back on Monday, and let's get after it again. Okay. All right. We'll see you on Monday morning at 8:30. Okay.
Can you get us the list of
names and then any exhibits for Monday's? I think the only, I don't know who is being called. We can find out. Ms. Love and Ms. Hilton and Mr. Atkins, who is going to be called? Let's assume that Mr. Copeland invokes again.
Your Honor,
Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So
Okay.
we
Fair enough.
we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay. Well, be thinking about what scenarios you'd like to have the court look at.
Yes, Your Honor.
Depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Sharp, he can have the floor.
Yes.
I'm just going to ask a courtesy of the deputies, could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to.
And Steele is texting, right? Steele is probably not paying attention. He's texting.
Lieutenant Walker.
What's name's on his computer? Those two are on their computer.
And Your Honor, the state has a matter we need to.
Look,
Okay.
Okay, nobody's paying attention.
Lieutenant Walker has been asked by defense counsels.
See that, right? Nobody's
as a corporeal body.
Yeah.
For them to be able to talk with their clients once you clear the courtroom.
Yes.
Can you make that happen?
Yes.
Okay. All right.
So why did the judge
once
make it known that they requested an ex parte meeting?
You just secure it and let them be in here along with their clients.
Yeah, they weren't paying attention. You see, Weinstein was on his computer. Steele was texting. Yeah. They go, Shell, hey.
Oh yeah. Once.
So the judge said, okay. So why didn't he, just like he just said about the clients remaining after court, why didn't he explain to the defense that DA Love requested a ex parte meeting?
I don't think that it's not that he had the ex parte meeting. I think that it's that they had the ex parte meeting with the sworn witness. That's the problem.
I think that's what it is.
Because the defense have had ex parte meetings with the judge as well, and they've said it in open court and all of that. That wasn't the issue. I do think that her request for that ex parte meeting, because she said he asked for the witness list in case Kenneth Copeland doesn't testify, like send your list to them so they know who's going to be the next witnesses. And then she let Melnick say whatever, and then she asked for the ex parte meeting. I personally think that she asked for that for Friday that day. I think they went in the back, had they ex parte meeting on the ex parte meeting that they was going to have on Monday with Woody.
That makes sense. That makes sense.
That's my thought. That was an ex parte to the.
She even said she had something to talk to him about a certain matter.
Mm-hmm.
Yeah, I agree with you on that one. I agree.
Yeah, that do make sense. So they were plotting the whole time, and really the judge was unaware until, like you said, probably after court, they went in the back and spoke to him, and then brought that up. But the problem is, he went along with it. He should have told him no. As far as the part with bringing Woody in, who was a sworn witness already. Because when Brian Steele let him know that he knew what happened, oh yeah, he got hot in the pants. Who told you? He didn't care about nothing else but who told you.
So they had a debate on how it was recessed. There was a big debate on that I had seen, that there was a big issue with how he recessed for a moment because he was walking away as he recessed. And I guess you're supposed to be doing that seated before you actually exit the court.
Who had a debate?
Oh yeah, no. When I believe she's talking about when Brian Steele was still talking, and the judge got mad and he got up and said we're in recess, but he was walking away as he said it, and Brian Steele kept talking. Remember, the deputy came over and tried to take his paperwork, and he told him, "No, don't take my paper." I think that's what she's talking about.
Right, but the big part, the Georgia Constitution News had an issue with how he recessed because he was not visible to the courts anymore, and he yelled it as they said his back was turned walking away, and they said that that should be a form of a complaint.
Oh yeah, no. Well, I think he did that because he wanted to go off the record. He did because if you notice, every time Brian Steele would touch on a good point, um, he would cut him off. And remember, Brian Steele said, "I'm trying to make a record." He wouldn't allow him to make his record without cutting him off because he didn't want Brian Steele to get off what he was trying to get off because he knew what they did was wrong.
I mean, to me, we saw all what happened, but I think the telltale sign for it all was that it actually made the record when Judge Glanville, his court attorney or whatever, filed all those things. When he made his official record, when he sent it over to the other judge and granted the whatever he granted for them, the other judge to look at the recusal motion. Remember, he listed all these things that were going to be in his filings, and then his lawyer, his court attorney, filed it. When we read through it, it had the transcripts of that meeting, and on that transcripts, Brian Steele's thing made the transcripts. So regardless if he was trying to get it off the record or on the record, they left it on the record. Maybe because he didn't do it properly when he went to recess. I don't know why, but I remember us reading it and it made it, and we were all like, "Oh my God, it made the record!" So
Oh, okay. Okay. I don't think he intended for it to make the record though.
I think he was ready to cuss Brian Steele out, and he was so mad and heated, he just had to walk away. Sometimes you just got to walk away. And he said, "Jack, it's time to go." So they left.
You can feel like that. Like right now, I just got to walk away, but you got to do it in a proper way. You're still a professional, no matter what.
Well, I don't know. When I found out he had a service dog, I started thinking, does he really need to be on the bench? He got a comfort dog, and they take a lot of comfort breaks.
Does anyone know if that's a service dog or emotional support dog? There's a difference.
I think it's an emotional support dog. I think that's what I heard somebody say. I think somebody said emotional support. So
Because there is a big difference in the two. One is given to you and ordered by a psychiatrist, and one is trained to your medical condition.
okay, I believe I did hear somebody say emotional support dog, if I'm not mistaken.
Yeah, emotional support dog. So you keep popping out. I went downstairs.
I know. I'm sorry. I keep pressing the button. I got to sit this phone down. My bad. I keep accidentally going out. My bad.
Well, I'm looking forward to the oral arguments on these motions.
Yes, next week, guys.
Tuesday, correct?
Yes, sir.
I guess I'll be front and center with Miss Sylvia. You gonna be in the courtroom? Are you gonna be in the court?
Yes, I am.
Don't let Miss Love see you, please.
They're all gonna see me.
I sit right in front of her. No, but how many?
I've been trying to tell y'all they've been watching this channel from the beginning, from day one. I told y'all.
Yeah, you have. That's why you be scared to read certain comments and stuff. They be making you nervous, Sylvia.
No, I don't be nervous. It's just that I don't want them to get upset.
You don't want what happened to happen. You didn't want what happened to happen. You didn't want to be named in their legal documents. Like you was when Steele mentioned the other guy that wrote a article when Judge Glanville was saying that Judge Glanville knew that Woody was gonna plead the fifth. You was like nervous about that. You was like, I don't want them calling me. I don't want to be named. And then here you
I
go
wasn't
being named.
nervous. I wasn't nervous. He put my name in that paper already. I wasn't nervous.
No, it was a joke. I know you wasn't nervous, but you still didn't want no parts.
Miss Sylvia, you just said you don't want them to get upset or mad. You know, wise man told me one time, get mad, just don't get excited.
Get mad, don't get excited. Okay.
Yeah. Let them get mad.
But okay, so my question is, how many more responses do we think that Love needs to address? So we know that she needs to address the one about her and Hilton being asked to be removed, right? What other responses?
There's a total of 15, I think.
I know, but she doesn't have to respond to all of them, does she?
Yeah, she does if she wants to. If she wants to. She has to.
But she'll probably respond to the bond hearing ones. Oh gosh, she got a lot of work to do, child.
That's why she started doing it now.
She don't need to be up in this chat. She need to be at her laptop.
And she's still going to ask for a 48-hour extension.
You know what?
No extension given when she over here doing extra credit that we didn't even ask for. She got 15 papers to turn in and she over here writing notices. No, she don't get no extension.
I'm not saying she's going to get it, but I'm almost positive she's going to ask for it.
She'll probably just wait till 11:59 to
Anybody want to bet him on that? Anybody want to bet him on that one?
I don't think she's gonna ask for an extension. Like she needs to be in all the good graces as she can. Like she can't give
how
her.
Sure are you? You want to bet him?
Sure, what we betting?
What you bet? What you? Okay, AJ coming in. Hold on. Hey, AJ.
Hey.
Miss Sylvia.
What's the wager? We're wagering here. I'm not paying any money. I'm not betting. I'm not a betting person.
All right. So here's the wager. If whoever loses the bet between me and Jones, since we're the one wagering, then we have to buy Miss Sylvia lunch for Tuesday while she's at them long hours at the court.
Sounds good to me, Shell.
What's the wager?
That sounds like a lose-lose bet to me.
Wait a minute. You were feeling strongly.
It's not always about you, Jones. It's not about you.
You see how he is? So he's not strong in his belief.
Now, I believe because she got so much to answer, and you already see how weak her responses are.
That's why she's starting now.
Yeah, but just because she's starting now, I don't know. I don't know if she has an answer, so she's gonna. I think I just say
wager not.
That is a lose-lose.
Backing out of it. You see him backing out of it.
He is. It's okay.
No, Miss Sylvia, you get lunch anyway. I'll cash app you.
No. We want.
How was it a lose-lose?
Okay,
we want a fair wager. We gotta do it.
Okay, Miss Shell. Okay, Shell. You gotta bet. Whoever lose, gotta buy Miss Sylvia lunch Tuesday.
Thank you. That's all we want.
That's it. So your bet is that she's gonna ask for an extension, and I say she's not gonna ask for an extension. Correct?
Yes.
All right. Deal. You got lunch.
Um,
You got lunch either way, Miss Sylvia, on Tuesday.
Thank you so much. I appreciate yourself.
yeah. So she'll be buying lunch for you on my behalf, Miss Sylvia.
You see, you trying to say you're gonna lose.
Hey,
Tell
I'll
Woody
take
he
my.
can tell Woody he can save his money for another day for you. Michelle gonna buy your lunch for me.
So he's that confident. Y'all hear that? He's that confident.
I'm just going off the history of Miss Love that I've seen. She's discombobulated right now. Those Woody's words, discombobulated.
Mm.
I mean, but she brought this on herself though.
She did.
Shout out to our newest member, Shannon Gagnon. Welcome, Shannon, to the infamous family.
What up, Shannon?
YSL Shannon.
Welcome, welcome, welcome.
Yeah, I really want to see the oral arguments.
It's gonna be off the chain, y'all.
She don't have nothing to stand on though, Doc. Like, what facts can she bring in to support any argument or rebuttal from any other facts and case laws that any other defense has brought?
I don't see any that she has, but here's the thing. She's gonna have 6, 7 lawyers at her back to back to back. I think she might fall apart.
It looked like she working by herself, man. I don't even think Hilton helping, man.
I think she wants to be in control. Uh Ms. Love is a control freak.
I can tell that from when she's not on the record. She's always passing notes. She's always trying to tell them what to say and how to say it. I can see that.
Yeah, her body language is horrible. I mean, she looks like a kid having a tantrum when she hears something that she don't like because it's hurting.
Yep, Gloria. I mean, she basically, with her motion, she basically pulled what she did in the evidence. She ran to social media to get stuff. Like, nah, lady, stay off of social media and build your case.
Right, right. Yeah, but I don't know, cause at first I thought Hilton was kind of intimidated by her until the day in court when Love was trying to grab that mic and Hilton snatched it. Like, no, you're not gonna say nothing. You done enough.
I mean, but if I'm not mistaken, the chain of command that's Hilton. Love is Hilton's boss. So
Right.
you're not finna go back and forth with your boss too often.
Yeah, but she wouldn't let Hilton get on. She wouldn't let Love get on that mic. Remember? Did you see that day when
I
Love
definitely,
kept trying?
I definitely did. But it's momentary lapses because they was
Yeah.
beefing for a while. You can tell from their body language and the way they was sitting and not talking to each other.
Yeah, because early on they were sitting next to each other, and then at some point Atkins sat in between them.
Yeah, a military guy, man. That's what I call
Yeah, I guess he was the buffer between them.
him.
But you know that, man. And this not taking a shot at women, but
Don't say
women get
it. Don't say it. Don't say it.
no. It's nothing derogatory. But you know, emotions run high with women because women are emotional creatures by nature. So them emotions get there, and I think if Mr. Atkins had not sat in between them, they might have gotten into a full out cat fight in that courtroom over the microphone.
I plead
But
the
I
fifth.
think I think Hilton was trying to save her some embarrassment getting on that because sometimes less is more, you know. And Hilton was just like, I think she's like, you don't need to say nothing, just because Miss Love has put her foot in her mouth quite a few times during this trial that I've seen.
So, chat, given the motions filed by the defense? What do y'all think the likelihood is of Judge Whitaker a ending this trial with a mistrial or granting bond? Because I like Steele's new motion for bond. It was very clear. It was straight to the point. It was matter of fact. He laid out all the reasons why he should and how he's going to go about doing
Can I say this to you, AJ? This is what
it.
I personally think.
So,
I think that if she rules on the bond hearing, she's not going to grant a mistrial. But if she rules on that mistrial hearing first, the case is over.
that is true. But both, in my opinion, well, not both. If the trial still go on, it's a clear not guilty thus far.
Yeah,
But
but we
said you got to address the jury. So depending on the jury, they're gonna be over with anyway. Because as soon as one person be like, "Yeah, I picked up my phone. I know all about Earl and XYZ." So boom.
but how can they not know? And I was saying this to Miss Sylvia earlier when you got off. How can they not know with everything all over the place? Do you think these people are just living in a box where they can't? They still have lives to live. And in some form or fashion, at least some of them jurors know what's going on.
And I
Sylvia, excuse me, y'all. Sylvia,
Yes, ma'am.
look at your phone. I sent you something we can cover.
Okay, hold on.
and John, I think Stills will ask for a reasonable bond. 5 million is don't sound reasonable, but either way, he can cover it.
Well, yeah, I mean, Young Thug has it, but I don't. If it gets to the point to the bond, um, yeah, I don't think she's going to set no high bond. I mean, unattainable bond. Even though 5 million, I believe Thug can pay it, but I don't think none of the rest of his co-defendants can.
I mean, I think like what I said when I first gave my opinion about the judge when she first came. I think she's definitely looking and inviting any kind of out. But she can, grab onto and support legally. But I do think that she's going to give them something. Like they're not going to come away losers. So if they don't get the mistrial or the mistrial with prejudice, they're definitely going to get a bond or something. She's going to give them something. She's not going to sit there and deny 15 motions.
That
Like
that sounds
just
right.
just from public opinion, since that's what everybody wants to, lean on why they're doing what they're doing. If we're going to go with that, from public opinion alone, she's not going to deny 15 motions.
Tyrone, who said they gonna want cash? You tripping.
And they're not going to be $5 million in bond. That's outrageous. They're not
Yeah,
going to do
I said that because I think Steele actually mentioned a reasonable bond. He
Yeah,
said
he still got to still get paid.
they're still getting their money because believe it or not, rappers actually make more money when they sit down, even though it's unfortunate because they ain't spending no money. They ain't getting no show money every day, but
Yeah, if it comes down to a bond, though, I think it's going to be a reasonable bond.
yeah, it's gonna be about a meal.
Yeah,
He'll
yeah.
walk.
So out of all the
Sylvia get the
motions,
first images of him walking down those stairs.
that were written yesterday, that we read, which one was y'all's favorite? I like I don't even know which attorney it was, but I think it was like maybe the second to the last one that came through. Um,
Regarding which client?
huh?
Which client?
That's what I'm trying to remember which one. I have to go look at it. But which one did y'all like?
I like. I actually like Weinstein's motion for mistrial. I mean, needless to say, Brian still, you know, but Weinstein was direct. Yeah, he got to it.
But I mean, they all were good motions, in my opinion. Them some high profile lawyers, and they all of them are very smart. I'm surprised Mr. Harvey haven't talked as much though. And he has a rule named after him in the state of Georgia.
I mean, Ura was intimidated by Harvey. I can see that from watching the trial in the duration. He did not like when Harvey spoke, and he denied dang near everything. I'm
But
gonna
why?
motion for severance. Okay, I'm gonna note it. I'm gonna deny it right here.
Yeah, but why did he go at Grandpa Bots like that though?
I mean, cause he had to deflect at that point after the ex parte came out. He was just discombobulated.
But that happened before the ex parte. That happened that Friday when Mr. Bots told him.
I don't care. I mean, I already told you. He knew he was on
Yeah,
plead the fifth. They was talking about the pleading the fifth.
yeah,
Yeah.
and he totally went in on Mr. Bots. Mr. Bots told him that's fine.
Yeah. He said, don't say it again.
Somebody said, and I'm not sure if this is true or what, but I think somebody said in the chat that Weinstein responded to, I guess, the gag kind of motion.
Oh yeah, he got a tweet out. He said basically, I'm gonna keep talking because it's important for my clients to get their free.
Oh, he just made a tweet. Oh, okay.
Paraphrase. But yeah, Todd Glass, Lil Baby is on the record for giving Thug a meal. So I think he's straight.
Oh yeah, well I mean, I think Thug probably still got the money, but
You see, they telling him to cut down your wardrobe. Damn, Thug, all this spider in the closet, man.
yeah, but Lil Baby gonna be there. Lil Baby said it on he said it out his own mouth like Thug paid him to get out the streets.
Yep.
Like
You
so.
remember you remember the defense witness list?
No, I haven't seen the whole list.
Do you know some of the names?
I think they got Ti.
Yep.
Was Lil Baby on there?
No.
They don't have Lil Baby.
Was Dominique on there? Chat, was Dominique on there? I don't know. But go ahead.
I got the I wanted.
Oh, they got
Worry about
big.
Hart. I know you posted it, Silver. I wasn't, asking to do it again. I was just trying to go off top of my head.
Don't they have Big Jeff on their witness list?
Yeah.
Correct.
It's
one more big name you ain't saying. Well, to me, big name. So to Atlanta, big name.
I don't know. I'm be honest with you. I can't think off the top of my head.
Michael Render. You know who that is?
No. Oh,
Mike.
Kevin Lyles. Kevin Lyles also, I think.
I was gonna say Lyles next.
Yeah. No, I don't know who is Michael Render.
Big Killer Mike.
Oh. Oh yeah, they might not be ready for him.
Man, you understand what I'm saying?
they might not be ready for him.
Gonna be like witness. Can you instruct him to stop talking?
Yeah. Yeah. That brother, he highly intelligent.
We understand that, Nina. We just talking. These are jokes.
Yeah.
Which attorney wrote the motion that wanted the current judge off? That he kind of came for the current judge. Harvey, yes. That was my favorite motion. I think Tall Glass said that's the one that's gonna get dismissed. Maybe because she's in it.
Oh, Harvey's trying to get Whitaker recused?
No,
he wants to get dismissed because the judge don't know anything.
Oh, okay.
The chat is really engaging. I'm gonna do a poll with the chat really quick. If whoever think that
Put it up there.
y'all look at the side, you guys are going to do them with the 5 emojis on the side of the screen. If you think this trial is going to end in a mistrial, drop the 100. If you think the trial is going to be dismissed, drop the heart. Take a poll real quick. They got the hundreds coming through left and right. Use the emojis off on the side, guys. Use the emojis off on the side. Oh,
Yes, emojis, y'all.
Wow, wow, wow. Mistrial is winning. Here come the hearts for dismissal.
I mean, they both go away, right?
Yeah, both is
Right.
the same thing.
Yeah, if a mistrial is granted, the way the motion was written, saying
Wow, okay.
John said, "What about a conviction?" Hey, John, won't you come on up, man? We welcome difference of opinion.
John's scared to come up.
Oh, that's that site. Was that the dude Cavell talking?
Yeah, that's the one that we got the troll definition for, who just says something to just go against the chat to evoke emotion. He's evoking emotion right now.
I mean, that wouldn't be
He
bad.
said he did not do panels. There was a couple things he did correct on here. From what he was saying, it looked like the chat was engaging with them on some of the
No,
comments.
that was a different person. That wasn't that one. That was what's the name who said didn't do panels. John didn't say anything about panels.
It said, he said, and this is all blabber from me. It very well could be no bond still. It looked like he goes back after and then will correct it and then put another one in there. John, you have a lot of information though, John. So you've been researching some stuff. So you should come up and share your platform on what you've seen. It's not a personal attack. They're just your thoughts and they should be welcome.
Why is your phone so loud?
Is it?
Mm-hmm.
Yes, it is.
You're about to
It always is.
go deaf.
Okay, y'all chill out. I'm gonna turn the hearing aid up one. Chill out. I ain't got one, but chill. I got you. Is that all right?
No.
You got to go down to like 2.
Good God.
Yeah, you loud.
Is that better?
Hell no.
Yeah,
I mean,
that's a little better actually.
Well, y'all seem extra
But no,
loud
it's
to
not.
me.
But no, it's not better. It's not better. Sorry.
It's not better. It's
not
loud.
better at all.
Let me move it. Okay,
Maybe
that's got it.
maybe you should put your phone down somewhere and like step away a little bit.
Yeah.
I'm not on a phone.
She's on the headphones. You got
That's
something there.
why.
Yeah, them headphones too good.
That's why.
I'm not on a headphone. I have my laptop open in front of me and I have the volume app literally 3.
Go 2. Go 1. Keep going.
Do you have a microphone?
That's a great computer. What is it?
Are you
No.
using the mic from your laptop?
Yeah.
I don't know. Walk away from it. See if we hear you.
Yeah.
Lord.
Are you talking? Mic check. Mic check.
Not yet. Let me fix it. Okay, that should be better.
Right.
I think I just had it too close to me. I'm typing with one hand. I got it at arm length now. That's better?
A little bit better. Better.
That's cool. We see that's just not gonna improve.
That's that good laptop, that Dell.
That's why I be saying 2 mouths because you be so loud. Like it's like
I'm gonna change it. I'm gonna put 2 mouths and 2 heads.
2 legs.
And then tomorrow when I come on, it's gonna say 2 legs and 1 hand.
Yeah, keep tricking us. Switch it up. Switch it up.
Dude. Or I need to go get my hearing checked.
That does sound a little bit better, but
I had it close up. I had it close up on me. I'm working with one hand. I got one hand in cast.
yes.
Your
Okay.
voice is giving yelling though. Is that your regular voice?
My husband said,
I
"Yeah."
think it's her tone. I
Oh.
think it's the tone plus her, just like her tone that she can't help, and then like maybe that the computer is
Cool
closed
though. We ain't complaining.
because she has one hand, so she has to have the laptop close.
Y'all, it's so far away from me now. I know y'all can't hear me the same.
Oh, we hear you very
We
loud and
hear
clear,
you. We
but
hear you
it's
clear.
better. But it's better.
We
It's better on our eardrums.
Good God, I'm gonna have to pay for everybody a hearing aid. I blew y'all.
No,
No, you blew our ears out.
That's what I'm saying.
for 7 hours yesterday.
Now I'm trying to whisper. Well, no, not for 7. They said I was too loud, and then at the end, I'm too low.
But anyway, what was he talking about?
Yeah, let's move on.
So what does the poll say? Majority people coming
Sylvia,
out with a mistrial?
I think it was the hundreds. I can't remember what that was meaning.
So it actually came up. It actually came up 51-49.
Girl, you got the statistics. You all up in Miss Sylvia's back office. How you can count them things? So you must be in Miss Sylvia's back office. You certified.
Ma'am, I'm here to assist her. I'm quiet. I'm just here to assist her. But they think dismissal is going to be before, or they think mistrial will be before dismissal.
She is not in my back office.
Okay.
But it's basically the same thing. A dismissal, mistrial. You know, I mean,
It is not.
Well, it depends on what is granted.
I think
One can come back and one cannot.
So mistrial can come back, right? Because it's not mistrial with prejudice. So are you saying dismissal is pretty much a mistrial with prejudice?
It's a acquittal. Yes.
Mistrial is mistrial. It's done.
I know, but then you say mistrial with prejudice means that it's done as well.
No, mistrial. Yeah, with prejudice. Yeah.
So
Right, but if they put without prejudice, then that means they can come back at any time and try to do it over again.
Right, that's true. But what I was saying, because the way the motions were written, that's why I say it's the same thing. Because when they use the word goaded, jeopardy attaches to that. Jeopardy attaches, which means it's automatically with prejudice.
Not necessarily. That word is used a lot, just stating the state has forced them to be in the position that they're in.
Okay, so I just saw what Justice Matter says, and I think I saw someone else. So there's dismissal without prejudice.
Yep.
And then there's dismissal with prejudice.
Yep.
And then there's mistrial with prejudice and mistrial without prejudice.
You just said the same thing. You said mistrial.
No, she said dismissal first.
Yeah, I'm saying this. You're saying both dismissal and
Dismissal
mistrial
with prejudice.
They both have with or without prejudice.
Yeah.
Dismissals don't. Dismissal is just dismissal.
Well, you just look what you just put. What Justice Matters, or somebody pinned that comment. It says dismissal without prejudice can come back. So I'm saying, does that mean dismissal with prejudice means that it cannot come back? So to me, you're saying that dismissal and mistrial has both with and without prejudice.
Okay, right here. Look.
Where's our honorary
mistrial has with and without, but dismissal doesn't have it. It's considered with prejudice. Okay, that's what dismissal is.
Okay. Are we sure?
Now,
a A mistrial is declared when it is impractical or impossible to finish a case. Mostly that happens with a hung jury. A dismissal results in a complete termination of the case, either at the defendant's request or due to other reasons.
Yes.
Okay,
And
so
then you have to factor in, is it with prejudice or without prejudice? That's
okay, so can you read the two overall definitions again? Sorry.
without prejudice. A case dismissed with prejudice is permanently over and cannot be brought back to court.
No.
With prejudice. Without prejudice, a case dismissed without prejudice allows the plaintiff to potentially refile the case after addressing any procedural deficiencies.
That's true.
Okay, so you Sal is both, I guess. Yeah.
Yeah, but I get that. I think both have with and without prejudice, but I wanted her to read the overall definition of dismissal and
Okay.
mistrial again, just the overall definition of those both.
Okay.
So that one for mistrial, it's declared when it is impractical or impossible to finish a case. You see that happen mostly with a hung jury. Dismissal results in a complete termination of the case, either at the defendant's request or due to other reasons.
Okay. So the first one is usually just with the hung ugh, y'all know the 12 people.
No, it's just we see it mostly with hung juries. But with this case having a little bit of everything, it could go either way. But obviously, everyone's going to fight for it with prejudice. So that way it cannot come back because of the type of errors that have been made.
Yeah, I feel like it would be almost unfair, not almost, completely unfair to give the prosecution another shot because now it's like they were like, on practice team and now they can come back and get their plays right. And that doesn't seem to be fair at all. If they even came back, which I would like to say I doubt they will, but with Miss Fanny, I think that she definitely would try.
Well, dismissal is going to automatically come with or without a prejudice. They have to choose one. If Judge Whitaker decides to dismiss, she has to choose: is it with prejudice or without prejudice?
Well, then I hope she dismisses it with prejudice. That would be the best. In my opinion. And then the other thing, Miss Sylvia, I know in panel and chat, I know that you guys are saying like, oh, we want to hear other opinions, we want to come up. I honestly did not come to this case like interested in it in a bias. I just came because it was just the S show, from what I saw. And so it just continued to be that. So all we wanted, and I've said it before, is just justice and then, the law to be applied correctly and everybody to have a fair trial. So it's obvious that that's not happening. So it's very difficult to get somebody on the other side of the street, you know. Um, because it's just so bad. It's just so clearly obvious. And when you listen to other retired judges on YouTube or attorneys, current attorneys, retired attorneys, they all say the same thing. So it's difficult to probably find somebody from the other side of the street. And that's not our fault, But we welcome the voices and the opinions, but I just don't think that there are many of them out there. And the ones that are, I agree with Chad that they're probably just being trolls or whatever you guys call them.
All right, let me go ahead and say thank you to the super chat folks. Thank you, Kimberly Black. All right, let's see who else. Thank you, Pete, for your super chat. Let's see. Anybody? No. Okay. Thank you, guys. I don't want to seem like I'm taking it for granted, so I appreciate you guys for your super chat. All right, go ahead. Shell, go ahead.
Oh no, I made my point. I don't. That was it. That was my thoughts.
So which one is better then?
Actually, a dismissal, because if you can't bring it back up, but a dismissal and mistrial with prejudice is the same exact thing because neither can be brought back up.
So why don't they do a dismissal?
I don't think nobody's filed for a dismissal, but the judge can still do that.
Did file for a dismissal. Yes, it
I
did.
think somebody filed for a dismissal.
Yeah. I think it
Oh, I
was Steele.
thought.
I think Steele did.
Oh, okay. I thought they all filed for mistrial.
No,
with prejudice.
Steele did it before.
I believe it's still open, Sylvia.
It's still open?
Yes, that went to Rachel Krause, and she did not rule on that. So that should be rolled over to Whitaker right now.
Okay.
Oh, okay.
Because I know
Yeah. How did she just ignore certain parts of the motion? Like, how'd she do that? Like, if she was given a motion to rule on, how she just don't ignore one part of the motion?
I think she just didn't want to be part of it. She just wanted to go ahead and do the crucial part and just say, "Hey, I'm done."
And I believe she was just trying to save face for Judge Glanville too.
She said, "Could y'all put the screen, Google screen, please?" I'm not the one that's doing the Google, so I'm not Googling it. That's two head, two leg, two nose.
I think she's reading out of a book, actually.
Yeah.
I don't know if she's Googling it.
That's two legs, two head, two nose.
Or whatever she's reading out of. I don't know.
What's the question? I'm sorry. I was in chat. What's the question?
They didn't want you to, they wanted you to put what you were reading on the screen so that they could read it for themselves.
I'm not
like the definition. I know.
Oh yeah, I can't screen share, so Miss Sylvia would have to put that up.
No,
you guys can look it up though. It will give you all the terms. If you go into online law dictionary, it can help you too, just to understand some of the wording too. Because I know sometimes they use a lot of legal terms, and a lot of people try to weed, between it. Those are just good just to have as a reference.
Yeah, I'm like Woody. Talk to me in regular English I can understand. Talk to me in a way I can understand it.
Yeah, I don't have. I'm not doing the Googling.
The legal law book dictionary.
Yeah.
Yeah, too much. But we appreciate your services too.
Okay. Here, I got somebody send me a message. Hold on, I'm gonna read y'all what they send me. They said a judge can dismiss a case at any time for legal reason. Only the state and the judge can dismiss the case. The defendant can only file. Hold on. I gotta open this up. Hold on. The defendant can only file for dismissal or request the judge to dismiss with prejudice. That's the message I just got. And y'all know I got connection. Let me stop. People watching this live and sending me messages.
They in the bushes trying to clear it up for us. Thank you.
Thank
Bishop.
you. Appreciate you.
We appreciate your services from the bushes.
We got a lot of legal minds that watches this channel. Y'all know that, right? Okay.
Clear it up for us common folks down here.
Because I'm very common. All right. Thank you, Kia, for Cash App. I haven't been looking at my. Let's do. Okay, here we go. Where did AJ go? He left us?
He's in the chat.
Okay.
So I guess we'll find out if we're gonna have a trial or not within the next week and a half.
Y'all don't think we're gonna have a trial?
I don't think so.
I mean, honestly, I'm not really looking forward to being attentive from 8:45 to 6 p.m. I probably would end up having to catch the replay, the replays, like where they like break it down, like when Cupboy puts it all together in like a 20-minute shot. But I definitely am here for the 30th. Even if the 30th take all week, I'm here for all of that. But when we get to trial, I might be worn out by then if we have to do that, because I will feel like, why are we still here? You know, I would just, it would just be untasteful to me. So I don't know if I could sit through a trial till December. Sorry, Miss Sylvia. Love you, but I don't think I could do it.
Why she said
Yeah.
that picture of it is a trial. She'd be right up on in the chat. How much you make a bet, y'all?
I'll pop in and out, but I can't be there from 8:40. I can't be here from 8:45 to 6 p.m. Okay.
You be in the ear, it'll be in your ear. Yeah. Y'all know y'all addicted to this stuff, so stop it.
I'll come back for the after party. Like when you come back from court, like I'll probably do that. When you come back from court and you give us the tea on the details of what happened and like the inside man stuff, like I'll be here for that for sure.
Oh, okay. You're not gonna be there for all the other stuff. I don't recall.
Now,
Here's a
Woody has
question
to
for
get back on that stand. If he gets back on that stand, I will definitely be tuned in front and center, firsthand account. But other than that, I'll catch you on the after party on the ride home from the courthouse after you done ate dinner and you telling us, all the juicy
Remember,
details.
I can't be in the car no more. Remember that.
Listen, never mind. You a grown woman.
I can't be in the car no more. I'll be in trouble. I can't.
Well, we want you to be safe, but yeah, it's okay. You can wait till you get home and tell us.
Hey, I got a question for all of y'all. Well, first of all, I don't think we're gonna see Woody again on the stand. I really don't believe that. But do y'all actually believe that this judge has no knowledge of this case like she claimed?
She's not detailed as us. No, I don't think she's detailed. No.
Well, I don't think she's as detailed, but the way she is, like, because some of the things some of the things, huh?
She has her own cases. You think she's gonna just sit around watch YSL?
Right? No. I know she did. I know she isn't, but she has some knowledge.
Yeah, she didn't say she didn't have any knowledge. She says she doesn't know this case like anybody else that's in the case.
I think what she does know is all of the bad stuff, like all of the oh, that was out of order, or oh, that was catty, or oh, like anything that's gonna have courtroom gossip. Pretty much, she knows that stuff. Whether
And she said it, Shell, because remember she said I saw something, the stuff that's been going on with the attitude, that type of thing.
Yeah.
Yeah, she's mentioned that.
Yeah, she knows that stuff, but the real details of like why a ruling was made or what was this or what was that, she doesn't know that. But she does know the courtroom chatter, the little courthouse, the courthouse gossip that between the bailiffs, the court reporters, the assistants, the staff attorneys, whoever's been chattering and saying stuff, which they have, because there has been stuff to talk about. She's heard about that.
I think it's going to go to trial. Go back to trial.
I think so too.
Then why you didn't make that a poll, honey?
Cause I'm reading, it's my opinion. So I don't like to put my opinions in there, but I believe that she's gonna keep going. I think that the way she came parachuting down, I think that she is gonna to keep on with it. I don't think that she is gonna end it that quick because there's so many pieces she has missed. I think she's gonna let it go on for, my guess is about 2 weeks before the stop is put.
But that's still gonna let it go. But listen. Here's the thing: if she sees anything that is out of order, constitutional violation, she's gonna end it. Period. Any constitutional violation, she's gonna end it.
Yeah, I think that's exactly what it is. I think she's gonna try to pick up where it left off, but I think that she did put some keywords out there, like the if word, if trial continues, or if we get to that point. Those are good keywords just to look into, but I don't see this stopping right here. For the fact that it's a lot of motions out here that she has to get through. I don't think she's going to have a response that fast.
Yep. There you go. Right here. I believe this one right here. Right here. I agree. Right here. With justice matter, I agree.
Yeah, I just read that. It's going to take about 2 weeks of argument, I suspect, on all the motions. Once she lets them get out all of that, that's where I think she's going to put the hammer down and say, okay, this is done now and over. I don't believe Woody will see the stand again.
Who's this?
But then you never know the mind of the judge. I mean, Judge Krause did say she didn't see anything wrong with it.
But there's other things that happen in the case, not just.
Absolutely. Absolutely.
I talked about the information not being given, Brady violation. If there's been Brady violation, that's a constitutional violation.
I personally find it hard to believe Judge Krause didn't see nothing wrong, because I've been in chats where actual judges and every lawyer that I've seen said that was illegal.
I mean, so someone said that, what did they say? That you have to understand how immunity works. Woody is not done. And so I think that you guys said Woody's not coming back to the stand. Well, that means that they're going to throw out all of Woody's testimony, because there's no way that the jury can hear one side of Woody's
They're gonna have
testimony.
to. They're gonna have to remove him because according to the law, they have to go back from where it ended. So that was Woody's testimony. So most likely, if that's the case, he won't be back unless they have him for something else and he has to answer the question over. I don't know. It's kind of weird.
Oh, somebody asked earlier, like, the best motion. I think that was the best motion. Brian Steele filed it. about disqualifying Woody to come back on the stand.
I mean, I
Once
think that would mostly cripple their case if we are going to carry on with this trial. That would be most crippling. So if we're carrying on like with the trial, to get that out would be the best for the defense. Even if they don't get bond, even if they don't get anything else, if they get, we have to be stuck with Love and Hilton. If they can get Woody, his testimony, you know, and all of that out, all of that, those videos, all of that out, then that would be the best for this case. Even if it went all the way, I think.
And according
Well,
to
you have to remember, though, they're on the witness list now, so they can't be on the stand giving testimony. And who's going to be at the table? That's an issue. They are witnesses on the list now. Let's not forget that. There's so much wrong within this. Like we go from topic to topic, and it's all these different issues that are still not hashed out.
Yeah, but I mean, if she rules that is no merit or it's not valid or like they
It's no
said,
merit to have no one at the prosecution table for objections.
no, what I'm
You can't
saying
play
is,
both sides. You can't be a witness and then speak up from the witness stand
but,
as a prosecutor.
but what I'm saying is if she rules that if she, let's say she rules as in the way that Cruz ruled, right, saying that the prosecution nor the judge did anything wrong in the ex parte meeting. Let's say that she did that. If she did that, if she agreed, or if she lets it be that way, then they come off the witness list.
No, they
Like
won't.
they wouldn't.
No. That does not work like that.
No, they
Oh.
won't. They have to. They have to do a testimony thing, even if it's one. Because when they question Woody, then they're going to question them about what happened in that meeting.
Correct.
Then the
That
judges have to be the one to make
But
a decision, huh?
but she can also like restrict the line of their questioning just because they want to question Woody in a certain way, or just because he wants to ask certain questions doesn't mean that she will allow it in.
They're going to allow it because it's on. They're going to ask question regarding to the ex parte meeting itself, what was said.
she's the one that's going to be in the box getting the questioning from defense from cross. She can't stop that. They have every legal right to cross-examine her.
Okay, and then remember they had this part too. Remember, look. Remember she was texting that girl, Bennett. There are two issues going on.
yeah,
The line of the issue was, remember when I told you, what did I tell you? How did I manipulate you? Those aren't usual questions you hear from a prosecutor that has their own witness on the stand. So regardless if you parse everything out from the beginning, all this stuff has not been addressed. This is all stuff that was swept under the rug to deal with later on down the road. Well, the road is here now. We're
And
here.
I'm sorry. Music Sergeant, you said the ex parte issue is over. No, it's not. It's not over because if the judge could let it continue, they got to figure out whether or not that there was a violation in regard to the sworn witness being there. The sworn witness situation, was he intimidated, forced to change his decision of taking the fifth, or what? They're gonna have to do that. Did he feel like there was pressure in him? They're gonna ask those type of questions as well. So it's not over with. That I know for a fact.
this looks to be like, and I could be wrong, just my opinion, but this looks to be a malicious prosecution. It kind of reminds me, and I'm get into it, but it kind of reminds me of the Travis Rudolph case in Florida.
mean the football player?
Yeah,
Okay.
that as far as the malicious prosecution, not the details of the case, but as far as the prosecution, like that case should have never went to trial. This case right here, from everything that's been presented, should have never gone to trial. Like you haven't even got to the defense case, and there's so many issues with the prosecution's own witnesses.
Okay, I want to ask something because everybody on this panel is on one side. Can I ask you questions, Mr. Jones, in regarding to you thinking a little bit differently?
Yeah.
I know it's going to be very hard for you, but I just need to find out. So,
Sorry, not to cut you off, but it's about fairness. If they were doing everything the right way and the evidence showed it, I'm for a conviction.
okay. What do you have you? I can't even ask the question. Have you seen anything that the judge did right?
Yeah, I mean he didn't do everything wrong. I mean I seen a couple times where he really got at love, you know. But with that being said, he allowed her to argue with him. She couldn't accept his rulings that went against her. And that was the only thing. Like you make a ruling, you stick to your ruling, you know. And he would allow her to argue and argue and argue. But the defense, especially Sharp and Steele, it seemed like he just had something personal against them. But no, I've seen him get at DA Love, ADA Love, and he really went in on it. It kind of shocked me, but he was right. You know, he's made some good rulings, but it's just overwhelmingly bad rulings that he made in favor of the prosecution.
So, do you think it was more of him having lack of control of his courtroom, or do you believe he was?
Oh yeah, he definitely didn't have control. I don't think he had control whatsoever. I mean, and then the times you've seen him gain a little bit of control, he had to really get aggressive,
Mhm.
you know, and both sides pushed him like that, especially Steele and Sharp. But I think that Steele and Sharp were doing it, looking out for the best interests of their clients, and Love was just doing it because she wanted her way.
Mm-hmm. Okay.
Nah, and Judge Glanville, I don't know in person. I don't know nobody dealing just from here, but he seemed to be a mild mannered guy. He seems to be somebody, and I heard the lead attorney say like he dealt with him and he was a great man. He said until this case.
That's what everybody said. A lot of people said that.
And I can see that in him. But when you look at this case alone, you know.
Do you feel he was overwhelmed with this case and he should have gave it to somebody else, or?
If he knew he couldn't be impartial, then he should have gave it to somebody else. He should have given it to somebody else. But if he could have done it impartially and not been so one-sided towards the state, yeah, I think he had the potential to do a good job. But for whatever reason, he allowed, I guess the pressure of it got to him. But that still doesn't explain or excuse the biasness against the defendants, because they're presumed innocent until proven guilty.
Okay, KK put in a statement that he was stressed and rule off of emotions. Do you agree with that?
Yeah, I do.
Okay.
I do. I think yeah, that it's stressful. I'm quite sure it's stressful for you, and you just vlogging about it or in the courtroom. You're not a part of the actual case. I'm quite, for a lot of us watching it is stressful.
Yeah.
So I know being a part of it is stressful. So yeah, I think, yeah, and being fair to Judge Glanville, I don't envy, the position he was in with this case. I don't, because I've yet to see anything that even remotely resembles anything Rico. I think he was just is this an election year for judges in Fulton County?
Yeah, he got reelected.
Oh, he's already reelected?
Yeah, because there was no opposing candidate.
Oh, okay. So he ran unchallenged.
Yeah.
Oh, okay. So that shouldn't have been the pressure on him, because a lot of times when it comes up for elections, you see judges do things, judges, prosecutors, whoever, do things that they feel like the public wants for reelection. But if he ran unopposed, then I don't, I ask, well, is it something that the prosecution have over him, or the DA's office, or what? Because some of his rulings were just unfathomable. Like, even in the when you break down the objections, he overruled the defense at probably a 9-to-1 ratio, as opposed to the prosecution. They object, sustain. He even made he even did one time. There was, the state was of course, the and one defense counsel objected. He overruled their objection. But then when the defense was on cross examination and the same subject came up, the state objected, and he sustained it. I've seen him do that like 2 or 3 times. And I started asking, is he confused? Is he not really aware of what's really going on in the court? Because sometimes he was looking disinterested. You see him sitting up there, you can hear him chewing his candy.
I heard some of the defense attorneys say it, other attorneys say it, and even this current judge kind of pretty much alluded to it, that this case is just too long. Like, with as long as it went, or as long as it's going, there's going to be error. The longer you have it, the more opportunity there is for appeals to happen, and and different things to happen and take place. But I think that has to do with just the prosecution not being ready. Like, they should have been ready to go take this to trial when they did their indictment. I feel like it kind of seems like he was buying them time in a way. Like, why did it take 10 months to select a jury?
Jay,
Like,
I can answer that question, and I thought about the same, Miss Sylvia.
I thought about that. And remember when the case first started, there were other
I was going to tell her what
prosecutors.
happened. I was going to tell her what happened.
Oh, okay, go ahead. I'll let you tell her then.
Gary was the prosecutor that was there at the time. And what happened is Bonnie asked Gary to step aside and let Love lead because she felt that a white male going after these young black boys didn't look good. So when Gary was told to take the second chair, he decided to quit. And he quit and took his stuff with him. So, and that's what happened.
So they lost pretty much all of their evidence. They lost the meat of their case to find guilty. So now they are over here piecemealing it together,
Yeah, because
and
they
then trying to sell a jury on convicting them. I mean, at
yeah.
the end of the day, they shouldn't have been so hot headed, and they should have just regrouped, went back to the, what did Kayla call it, the fire room, or the whatever the little room was, where they had the pictures all over the place. They should have just went back to the drawing board. They didn't have to be so stubborn and bullheaded to carry this on, that the way they have, because at the end they're not going to get another shot. Like, it's completely unfair. And the thing about it, to me, which even makes it more unfair, is that there are murders in this case. There are people that lost their lives. There are families that lost their loved ones, and there is not going to be justice rendered in that because they wanted to be hot-headed. You know what I mean? And that sucks too. So that part of the situation is not good for either parties. It's not good for nobody. It's not a good look on them. It's not fair to the defendants who are innocent until proven guilty. It's not fair to the family members who, lost a loved one or that suffered in any of this. So it's just all bad in my opinion, and we just need it to be over. Unfortunately, they gonna have to try another way.
And then
Try another way or whatever. And if they're such criminals, they're going to be bound to do something that they can get them for something else for. I don't know if they're such criminals, but to me, it's like everything is 2007 and later. Like, show me, what did they do in 2022? Like, is this really a working organization? I mean, I think that they overly ambitiously like try to go for the gusto when they could have got did smaller indictments and got them for the things that they are guilty of, instead of just wrapping it into this big fat smorgasbord and calling it RICO. To my thoughts.
thank you so much for your thoughts. um, go ahead. Oh, he's gone. I thought it was. Yeah. Oh, here you go.
Sorry about that. I had to go out. My volume was.
Somebody must have called you. That's what happened.
Oh, okay. Because I have it on Do Not Disturb. So, yeah, wow. This, this case is a hot mess. And I feel sorry for those guys. Like, we're talking about almost 27 months of being incarcerated. That tells me you're not innocent until proven guilty. And just think, say that it ends in a mistrial or even an acquittal. Those guys can't get none of this time back.
No.
Look at all the finances that they had to put into this just to, you know, get themselves off. This is not a, they talk about the taxpayers and yeah, and that I agree with that. What about these guys right here who, from what it looks like right now, haven't done anything that they've proven?
Have they been charged? You said proven.
Well, nothing's been proven thus far throughout this case by the state. I mean,
They haven't proven one thing. And and I know I'm jumping, but I just thought about this. Here's what really made that ex parte improper and made it where there was material evidence. When Woody said, "I did these crimes," he never said he murdered Nut. He never said that. I never seen where he said that. And I've seen some people in chats say that, oh, he admitted to it. I think even Brian Steele said it when he first brought it up about it, where he said allegedly he said that he killed Mr. Thomas, but that was never nowhere that I seen or heard. But he did say, "I did these crimes." That's that's the Brady violation right there, and that's an old case from like the 70s or 80s, Brady versus Maryland. But I don't know. This is I hate to see him going through that. I mean, you do something, we all gotta face the music. We make our bed, we gotta lie in it. You know. But if these guys are innocent until proven guilty, why can't they have a bond? Especially with, like I said, I'm not from Georgia, so I wouldn't understand how it is down there. Just from what I'm hearing about the conditions of the Fulton County Jail, and I know they're all not in the Fulton County Jail, but still, especially ones that don't have prior felony convictions. What is their risk? I guess they're saying Thug because he's a global celebrity. He's a flight risk. But from my understanding, he's never lived nowhere but Atlanta. So where's he going to take flight to? Uh, those laws are kind of and that's not just Georgia. That's not just Georgia. It's not. It's happening all over this country. Did everybody leave?
I'm here.
Oh, okay.
I was letting you talk.
Oh no, that was it. I don't want to rule. I don't want to, rule the conversation. But and I'd rather listen to what you say. Yeah, I have things that I input, but it. You're there every day. I like how you gave all the jurors nicknames too. That was crazy.
Yeah, I miss my what do you call them? The draw. What is it?
Juror.
No, Snow White and the draw.
Oh, dwarfs.
No. I'm trying to give them a different name.
Oh,
because it's sleepy. Drawers. Draw. I'm trying to give them a different name so we don't give them the jury information.
right. Can I ask you this? This question, based off your opinion, from what you've seen in the court with the jurors, do you think that they would convict as for where the trial from where this trial ended, from where it started to where it ended? Did you see anything that would indicate a conviction?
No, hung jury if anything. The worst it would be a hung jury.
So really, this whole situation is a win-win for the defendants.
I would think so.
Like, even if this a mistrial isn't granted and they bring the jury back, because sitting on the outside looking in, I'm sitting here and I'm not just like, okay, it's Young Thug and they're not guilty because I like Young Thug. Like, um, but listening to the evidence, or should I say lack thereof, I didn't see no. There's no way I could see a conviction, and that's why I asked you because you were in the court every single day. Miss Sylvia, you need to get on somebody's payroll because you're doing a lot of work.
No, then they control me. I can't be in nobody's payroll. I don't want to be controlled.
She said, "Don't censor me." She don't want to be censored. I have a question though, Miss Sylvia. Now, don't get mad because I know Woody's your new friend, and he's all of our new friends.
There we go with the new friend.
Well, I mean, if I'm paid in the
No,
chat, I'm gonna say it.
you gotta say he's my new family member. Remember, that's what.
Oh yes, new family member. He's your new. He's the newest addition to your family.
Yeah.
So, this is just, you asked us to be objective, so I just want your objective opinion.
Okay.
Have you heard or read or looked at that Operation Phoenix thing?
Mm-hmm. Yeah, I heard. I have.
Do you think, what is your thoughts about Woody being on there and then being the star witness for this prosecution? Like, do you find that that's odd or strange?
As far as,
like, why isn't he, like, they said it before, they called him an unindicted co-conspirator. So, like, how does he make the top 12 most whatever dangerous people in the list, but then becomes a witness for the most dangerous, one of the most dangerous, gang organizations in Atlanta, according to how the prosecution is trying to paint it. Not saying that those are facts.
That is something I have not even sat to even ponder on, because it seemed like it was like a lot of crookedness that was going on in that operation. I mean,
yeah, it sounds like they renamed the Red Fox or whatever those guys were called. Was it the Red Fox or the Red Tails or whatever?
but remember, they were doing some intake of the drugs and all that kind of stuff, and it was, I really have not really taken the time to dig deeply into that group, but it is kind of strange.
Yeah. Oh, Red Devils. That's what they were called, the Red Devils before. And I heard someone in some chat said that they just renamed the Red Devils, that they still are working and operating, but Red Dogs. Red Dogs? Something. Red Dogs. Yeah, I think it's Red Dogs. That they're still operating. And probably maybe that's why they have that police reports that are
Missing.
non-existing.
But they said there was a lot of dirtiness that was going on, crookedness.
Yeah.
I intervened right there because I recall, I think I heard they said 88 Love said the system was hacked in 2018, so they lost those particular ones.
Carvel said someone has something to share, so I'm not sure if he's asking you to drop the link or not. Or
Carvel, did you want me to drop the link?
Oh, Antonio, if you want to come up, I think Antonio's saying, are you letting anyone else come up? So I
Yeah.
think, can you drop the link?
I just dropped it. Just dropped it. Just dropped it for you.
But yeah, it seems like Atlanta has been having some crazy corruption going on for a long time. And in my personal opinion, like even if the police department are corrupt, and they're, you know, doing things that are not right, I think that in order to even get the cases to convictions, they kind of you know, have to have help in that too, from like the prosecution or from like other, you know, ballistics or from whatever. You know, it's not like they could totally do it all on their own without any assistance, in my thoughts. Not maybe one person, maybe two, but not like, you know, hundreds of men and women without any assistance from other people above them.
Hey, Antonio, welcome.
Hey, Miss Sylvia, how you doing?
Good.
All right. I got a quick question because I just wanted to know what about even like the evidence that that they allowed to come in as far as Young Thug's rap lyrics. I think that should have never been been able to come in. You know what I mean? And I think that's what they are basically trying to pin him with or associate him with, those crimes that happen.
So your question is why?
Yeah, do you think why did they allow the lyrics to come in? Because that to me, you like everybody was saying, it's kind of a long shot or a long reach that the prosecutor them are doing to try to convict him of this here because you really don't have ain't nobody really said Thug did this, Thug did that. Even the star witness. So to me, only thing that I'm looking at evidential wise is his lyrics.
Yeah.
That's the only thing that I can think of because you don't have nothing else that that can hold him besides his lyrics. And I think that's why Steele was trying to drive it home so importantly that this is a record label, this is art. You know what I mean? You trying to use somebody's art against them, and I think that's the whole thing about um, targeting the African American community because most of our young black youth are music driven type people, and entertainment is our number one outlet. Entertainment and sports. So to me, it's just from the beginning. I just think the whole case was a screw up to me, just in my personal opinion. And even when it came to Woody with the immunity, like I did 10 years in the feds, like the feds can do what they want to do because they said that they gave him immunity on state and federal level. The feds, if the feds can come back and give you time on what they call a sentencing guideline, meaning that they look back in the past of all the crimes that you have committed, all the convictions that you have been convicted of, and they can give you time
Your
for
phone is
incarceration.
your connection is terrible. I tried, but it's like
Okay,
I
I'm
know.
on the road. Huh? Go ahead.
Antonio,
it's
Antonio, I remember you came in with a great prayer and we want to
Right.
hear what you have to say, but we really can't hear you. Is it your Bluetooth or something? Like you prayed us out good the other night. I remember you. But we can't hear
Yeah.
you. that good.
Can you hear me now? Can you hear me now?
Oh, you good. Oh,
Better,
yes.
yes.
Thank you. That's
Okay, yeah.
great.
I had to put my earphones in. I'm sorry. I
Okay, thank
apologize,
you.
chat. But
Go
what I
ahead.
was saying though, even I did 10 years in the feds. So what kind of confused me is the whole immunity type situation that came up about Woody. Is that, we grant you immunity as far as state and federal, but if the feds can give you time based off your previous convictions, what they call a sentencing guideline, what make us think that they can't come back and recharge him for anything that they haven't investigated or did they investigated on or take from this trial and possibly, convict him? That confused me because I mean the feds use double jeopardy all the time. You know what I'm saying? They use double jeopardy as far as like when I was a juvenile when I committed some of the offenses that I committed. So they even went back in my juvenile record and said, okay, because you did X, Y, Z, this is where you fall like on the sentencing guideline. So I'm kind of confused with the law in that area because everybody's saying, oh, he's immune from the state and the feds. But from what I understand and the experiences that I went through, they can come get him off just what he's doing on the stand right now. So I don't know if anybody else got any ad libs to that, but from my understanding of my experiences, they can do what they want to do. So that to me, they kind of railroaded Woody, for real, for real.
Yeah, that you made a good point, bro. The state don't have the power to give nobody federal immunity.
Nobody.
So when they told him that, that was a part of the coercion.
Okay.
That was a part of the coercion in that ex parte meeting, because the feds can't give nobody state immunity.
Right.
They're two separate entities.
Right.
We know the federal is the highest level. They
Right.
can come in and do what they want to do, and they can override the state. But when it comes
Right.
to stuff like immunity in criminal cases, the state can't. I mean, the federal can't come down and override the state. So for Ms. Hilton to tell Woody that he was immune from state and federal prosecution, she blatantly lied to him.
She lied to him. Yeah. Yeah. And that's what kind of teed me off because here it is a young man. And I think not before I say that, scratch that. And I think that's what made Woody go off and expose everybody like he did because he ain't no dummy. When it comes to the law, he ain't no dummy. You know what I mean? And I think that when they tried to play him like that, that's why he was so adamant about pleading the fifth. You get what I'm saying? But when they came in and said, we're going to force this immunity on you and so on and so on and so on, he got information that saying, oh no, I'm finna flip the script because y'all ain't finna railroad me like that. And I think that's how Woody was able to really help steer them out. To me, that's what he did. And he made the prosecuting team weak as water on toilet paper.
I think that
Yeah,
that's like why that's one of the things that Steele put in his motion, how they mis gave him the prosecution and the judge gave Woody wrong legal advice or explanation of the immunity order and what it protected. And that's another
Hmm.
reason why, I was irritated with Judge Krause. Like, if anybody should know, you should know that they, misled him in his understanding of that immunity with pretty much kind of saying that he has federal um, things. But, she was saying it in a way that she was alluding to, she was talking about a case that they had already talked about. Like, oh, I looked up the, whatever, however long you can go back. And then she was like, it's done,
Hmm.
the state done, federal done, like
Hmm.
they can't go back and get you. But she was misleading in the way that she
Right.
delivered it. And Judge Krause knew that and could see that, but clearly still said there was nothing wrong with the ex parte meeting, which
Right.
is a bull crap. Um, and which is why Still put it in his motions that we hope that Judge Whitaker will rule correctly on this time around.
Yeah, that and that was blatant. You cannot tell me that you're a professional lawyer, that you're an attorney, whether for the DA or defense attorney or a judge, and don't know those laws.
Right.
Everybody knows, you know. Um, every any person with
But
common
at the same token, he had lawyer representation there, and she didn't speak up in that meeting either, or on the record either, and say those same things that we're saying now. So
and sorry about that. You know how I look at that though. I think she knew what she was doing. And I think she didn't say some stuff on purpose to let the state put their foot in their mouths, and that's what happened.
Bingo.
I mean,
Bingo.
okay, that I agree, but this is the other issue. And see, I'd be mad that they're in this chat listening and looking at us. Um, but I agree. But I also think that they can.
You hit the wrong button again. Hold on, y'all. Wait till she get back in. She been hitting the button all day long. So how are you doing, Antonio?
Hey, I'm doing good. I'm coming out of Tennessee, headed into Virginia, going back into North Carolina. I'm finna
Oh,
go home. I've been on this road all night.
all right, Shell, you back. Go ahead.
Sorry, y'all. I was starting to get excited about this
You,
because I be started touching the phone again. But I think, and I don't really want to say it, but I do think that the state can use Woody and Kayla to kind of present as if they've been working with the defense all along. With Kayla, standing there not saying anything, kind of saying that she did it on purpose, not saying that she did, but they could probably try to present it in a way that it seems like they were trying to botch the case on purpose and helping in the defense.
Okay,
Unfortunately, I feel like that's why they ain't mentioned Rudy or Taylor's YouTube in their motion to squash or anything because I think they're going to try to find a way to backtrack to use it as they were lying on the stand. What he said in the videos was true, and they're in collusion with the defense. My thought.
oh, okay. Now, if I can respond to that, what you said makes sense. The only problem with that is when you say Kayla and Woody came together to do that. Kayla knew nothing. That was the first day she was a stand-in, and that was the first day that she came to stand in.
But that's not true. That's not true. That's what she said at first, but Miss Sylvia, she's talked long enough that we've realized that that's not true at all. Like she has so many other connections to the defense side of it, it's ridiculous. Like they could clearly make an argument. If I was a jeweler, I would believe it. Like they could make that a strong argument. Unfortunately, they could, in my opinion. These are my opinions.
Right. No, I mean, and like I said, I wasn't aware of that. I didn't see that part, so you could be totally right. I don't know. But I will say this. Um, I don't think that she had nothing to do with the ex parte meeting being sealed.
I agree. I concur. I agree. I think
You
that,
know.
she was, I agree that she didn't she didn't have an ex parte on Friday with Judge Glanville and say this is what we're gonna do on Monday.
Yeah.
She was just kind of, put in the situation, and I think that they used their, you know, friendliness and friendship, because she said at first they were just kind of peeking and like talking, with Love and like kind of catching up, and she said she liked Love. So I feel like, Love manipulated, maybe her position or their friendliness to kind of soften her up and then putting her in the judge's chambers, like that's a big thing, to try to give a little intimidation or make her a little timid in regards to like what she's willing to vocalize, at least on the record. So, I think it was both a setup on both parts, but I also believe that they can flip it and use it for their defense or to build their case.
But here,
My
the only problem with that, excuse me, 1 second, bro. I'm sorry. The only problem with that is anything that happened outside of after the fact of the ex parte meeting is a moot point because the ex parte meeting was illegal, and so anything that happened after that is null and void.
Yeah. I mean, like if that's the case, like if they say you can't talk about it, like I said, the judge can't make rulings on what they can ask, line of questioning and stuff, but that will go on both sides. That will go on still sides too. So
Right.
if she rules like that, then that goes on still sides too, which means that he can't ask what happened in that meeting. You know what I mean? So like if that's out, it's out. So
Can I ask a question? I don't mean to go back to what we were saying probably about 20 minutes ago when we was talking about what he has done on the stand. So how does that play out, right? I know that still them filed a motion to get rid of Woody's testimony, I guess, after the ex parte meeting, if I'm not mistaken. But how does that work if they get rid of his statement and if they don't put him back on the stand? How do the defense get a chance to cross him? You get what I'm saying? Because now the juror's mind has been tainted, or they have heard everything Woody said. So if the defense never get to challenge that, if he never gets on the stand, how is that going to work? Is they going to scrap his whole testimony as from the beginning all the way till now?
Um, Miss Sylvia probably would know more than me because she's there, but I'll say this: just being familiar with the law. That's why there will be a mistrial because
Right.
everything you just said,
Hmm.
there's almost no way to get around it.
You can't. You can't.
Um,
Because they already got a picture of what the picture that Woody painted. You get what I'm saying?
right.
So if you get rid of his testimony, if you get rid of him now, and the defense don't get a chance to cross him, man, that's a slam dunk for the for the prosecutor.
Right.
You know
Jazz,
what I
That's what.
mean?
Jazz says Steele never cited law in none of his oral or written motion to recusal, stating how Woody was being close course that would ID make I don't know ID make his testimony no good.
maybe ideally make his testimony no good. I don't know. But I mean, I don't know. Like, I don't have Steele's motions by my memory. Um, but I do believe all of Steele's motions that I remember and read that he always put case law in. But
Same here. I've never seen none that didn't have case law.
maybe he didn't in one or something. But I always see some sort of case law in Steele's motions. But
And I
that's
think, and
what I remember.
I think that even with Love filing her motion today, that even though Steele has a rapport with this judge that's on the bench right now, that's on the case, and he knows that she's about a law type judge. I think just even in that, man, once she get to hearing these motions, man, I don't think we're gonna get out of those 2 weeks because still already know that she is strictly by constitution, by law. She's not Glanville that just, fly by the seat of his pants. You know what I mean? So that's another thing that I'm looking at that I like about the judge that's on there now is that okay, we're gonna let justice be served and we're gonna let these brothers have their due process and they day in court. I'm gonna hold everybody to the letter of the law. You get what I'm saying? So to me, that's a slam dunk for Steele and the rest of his team.
But you know what? And Miss Sylvia, you asked me about this a little while ago. In all fairness to Judge Glanville, I don't think when this case started, he started out like that. I don't think his intention was for it to go where it went to. I don't, you know. I mean, and if that was his intention, then he need to be disbarred.
Yeah.
And
You
someone's
know.
saying in the chat that he didn't say it in his oral arguments. And again, I always remember Steele coming in with some in case versus da 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 with some numbers and stuff. Like he come with his little sticky notes, honey. Like I can't remember every single one of them, but just the way that he practices law, I find that hard to believe.
And if
That he didn't have no case law because he usually always comes with some kind of case law for the
and
most
then when
part.
he doesn't, he'll come back and get it. He'll go find it and get it.
Yeah.
And I second emotion you on that because he wouldn't be the top lawyer like that in Atlanta if he didn't. You get what I'm
Now,
saying? So his reputation speaks for, this man knows how to dot every I and cross every T. And I'm just thankful to God that, Jeffrey got somebody like him that'll stand in the paint for him, man. You know, the word says, will one die for his brother, man? One would merely think to die or consider to die for him. But this man stood in his stead like, yo, you can put me in the cell next to this dude, man. I'm gonna protect my client. And man, I just thought, man, that gave me chills to see that, man.
no,
Wow.
hey, that you know what? And you exactly right because when you look around the courtroom when he said that, everybody looking at him like, wait a minute. And
Yeah.
then when he got held in the court, then that's when Adam stood up and was like, hey, I take the same position as
Yes,
my
sir.
co-counsel. So
But
Yes,
did
he
sir.
did y'all
at that
see when
point,
Did y'all see what Shark came on Miss Sylvia's channel though? And he wanted to the same respect. He said,
Yeah.
"Me and what's the other one? Me and Adams was both ready to go to jail for our clients and behind Steele because we said he said I text my wife and said I might not make it home
I
I ain't
might
tonight."
not
coming
be
home
home
tonight.
tonight.
Yeah.
Sharp wanted in on that respect for I'm
Yeah.
gonna do anything for my client.
But
Hey.
here's the thing about that. This just funny. He sure didn't say it in that courtroom.
Mm-hmm.
Well,
But I'm
he
not.
did say he did back up the motion, but he knew, but he didn't say no. Take me in too. But
No, but he stood up. They all stood up.
they all stood
If
up.
y'all
But
was in the courtroom and when they turned the camera off, they were all huddling together.
yeah, but Adams did say because Adams said I expect the same punishment that you
Yep.
gave to Steele, and he said we're
I
not
didn't
talking
ask
about you.
you.
We're talking about him. Like well, I'm not gonna do like
Wow.
he was already like I'm not about to do that with y'all because he already
And that
knew how it was
and,
going. So
Mm-hmm.
and that told me right there he had something personal against Steele. Because why? If
Yep.
Steele didn't tell you, why didn't you ask one of the other co-counsels
Other
who got
co-counselors.
there? Why didn't you ask him?
Yep.
See, because he would have had to
Ex-
hold them all in contempt. That's why I know he had something personal against
mhm.
Steele.
he wasn't ready for that smoke. He was just in his feelings. He was having a hot head moment, and it took him all day to calm down. And it took YSL Barbie to come in there and YSL Ponytail to come in there to get him together. But he got himself together. Um,
Oh yeah, he came down there and laid the hammer on him.
Ponytail. Who's YSL
Yeah, she
Ponytail?
ain't played. Yeah.
the
The
guy
You
that
talking
came in, the
about
guy
Steele's
that came in
lawyer.
with Ashley
No, no, I'm
Merchant,
saying I know Barbie, but who's Ponytail?
the man
the
that was
guy
with
that was
Ashley
standing with
Oh,
Merchant.
her.
the guy. Okay. Got you.
Ashley didn't come in there. Listen, Ashley came in there for real. And I think Judge Glanville was kind of like, uh-oh, I don't messed up for real now. He tried to come back, be combative with her, but boy, she was spitting that fire up out her mouth.
Hey, did y'all recognize? I don't know if y'all noticed this because when she was up there talking, I'm looking on TV and I'm focused on love. She sat there like a mannequin. She sat there like a mannequin. She
Listen,
didn't.
they were all back in law school again, okay? They was first year law
Yeah,
students that day. That's what they was. They was first year law students, honey. She got them all together.
man. Hey, you know what? I hate to say this, and I ain't, with all due respect, man, but still the new Johnny. Still the new Johnny. Still is Johnny Cochran 2024. I'm just gonna put it out there. The boy is bad, man. The boy is bad, man. For real. You know, I think that team gonna go down in history like OJ lawyers did, man. For real.
But you know something? I'm gonna say this. Don't sleep on Keith Adams because he's so smooth with it.
Oh yeah. Oh yeah. He's
He's so
surgical.
smooth.
Yo, he's surgical. Oh
And
man, Keith. Oh,
I,
he's surgical.
I actually heard Miss Sylvia say one time that the jurors actually like Keith Adams.
Oof. Man, Keith's surgical, man. And he's so smooth with it. His whole approach, the way he set the chessboard up, man, it be checkmate quick too. And he sit on down. I say, boy,
Yeah, I
this
think
boy
I
here
think the
bad.
tone I think the tone of his voice just like captivates you. You just like want to listen.
Yeah,
Like, ooh, what does he have
yeah,
to say? It's like you're gonna
he
believe everything
does.
that come out of his mouth. Like, yes, you got it.
Okay,
Right.
somebody's gonna have to
And
turn down your Antonio, mute yourself, please, because it's hard to hear
Okay,
everybody.
yes, ma'am.
uh, I'm gonna tell you when he got me. When the Bennett lady was on the stand, and I didn't understand. Love, this your witness. Why is you're treating her like you cross-examining her? But then when Adams got up there, and like he said, he was so smooth and so surgical, he made her comfortable. And I think she really messed the state's case up before Woody ever come along, especially when she exposed that investigator for the DA's office trying to
Sorry, one
take her
sec,
on
Miss
date.
Sylvia. Jazz wants the link.
I put it in.
Okay. Sorry, Jones. Go ahead.
Oh no, no, no. That's when I knew. I said, oh no, this guy, Keith Adams, he's the truth. You know, Brian Steele, he the one, he the Superman. But Keith Adams, he that one for real. You know, because and that's all it is. In any case, it's about who can make the jury believe what they say.
Mm-hmm.
Because if you notice every time they talk about theories, well, theories are nothing but educated guesses for real. That's all a theory is. So it comes down to who is the most believable.
Yeah,
But
and I think like at the end of the day, I think that all of the attorneys are, are to be, commended and doing their thing, except the one lady. But anyway, the appointed one. But I think all their rates is going up.
oh yeah, nah,
All the rates is gone up.
and and don't sleep on Max Sharp. He don't mind getting dirty. He
Hey
don't
Jay.
mind getting.
Hey Jay, welcome.
Hey, I'm trying to show my face.
Let's just keep
How y'all doing?
good. How are you?
All right.
I don't know why I keep flashing back out.
It's showing and then going back out.
Yeah.
Okay. Is it in now?
No, it don't. It's unhooked. Just hit the stop cam. Hit the cam thing.
That's what I'm hitting, and it's going out every time I hit it. It says your browser has lost connection to my camera. Refresh.
You said Boosie got re-indicted. Who said Boosie got re-indicted?
Maya said that, and it's probably true because Maya don't tell stories.
When did he get re-indicted?
Maybe today.
It's still not done. I don't know why it's not done. But
We can hear
anyway,
you, bro.
y'all can you hear me?
Yeah.
Okay, so basically what I was saying was he never asked the judge to actually get his testimony completely removed. Once you remove his completely testimony and you can't cross-examine him, the case has to be dismissed because you can't have the jury saying a part of a testimony and not saying it at all. Really, it's just hard to move forward if you do that. So he never talked specifically cited rule. Here comes the petition such and such, blasey blasey with rule such and such, stating specifically with the rule that he was coerced into creating his testimony because such and such, this was said such and such, and I'm asking for his testimony to be completely removed. Completely. He never did that. He just talked about in his motions when he filed motions for other stuff to have him recused just because he had a meeting or just because this, he never specifically cited law or rule with case law to support. He just talked about it when it came to that. He never really sent the motion straight up, having him testimony completely removed. Because once your witness is coerced through the state, that's an automatic grounds specifically. That's just so tainted. He never did that. Or am I wrong? Did I see anything like that?
No, I don't think you're wrong, but
Yeah, I wasn't tracking what you were saying, honestly. Somebody else said, "Can you say it again?" So I wasn't really tracking what you were saying.
I couldn't understand what you were saying.
Yeah, sorry,
You
Jay.
couldn't understand what I'm saying now?
No, go ahead. It was like choppy to me.
Oh, jumping in and out. Okay. So what I'm basically saying, he never actually went after Woody testimony completely. Using the ex parte meeting. Because basically he was coerced, he was pressured, it was just a whole
Okay, there's something going on. There's some noise or something going on. Can everybody mute, please? Okay, go ahead and talk now.
I'm good.
Yeah, I think it was Mr. Jones' noise.
Okay. So during the ex parte meeting, Woody testimony was partially coerced, partially pressured. It was a little bit of all of that, stuff was lied. They lied to him about what he ain't gonna get it, so that was coercion, So he never strictly went after the guy testimony. He never went after Woody testimony completely. Once you erase his testimony, the case has to be really dismissed because you can't have the jury wipe out somebody's 4 or 5 day testimony and just move on. That's so hard to do. You can't erase it. You can't. That's why she's going to. If I believe she's going to rule the cases, but he never specifically went after his testimony. If he went after the guy Woody testimony completely, he would. That would pretty much wipe out the case.
I have a question. So, are you saying that Steele never asked for Woody's testimony to be completely gone? Is that what you're
Yeah.
saying?
Yeah.
He did. He did, though.
No,
He
not in
did
a
in one of his
motion.
motions.
Strictly motion. He talked about Woody testimony about how they did. It seemed like it was coercion. Yeah, he talked about it on the oral when that day he got held in contempt. He talked about it.
Yes, but he also did write a motion about it specifically, and he asked
Yeah,
for.
but I'm saying he didn't act strictly for his testimony to be what's it called. I've never saw none.
I
Here
mean, I'm not
comes
going to
such and
fight with
such.
you about it, but I
he,
do believe that he
he
absolutely
asked,
did.
he said in open court, and Judge Whitaker told him to put his motion in writing. He said he said his whole testimony has to be thrown out from the time from June 12th when Weinstein filed his motion to recuse, from that day, because on June 4th, June 12th, 13th, 14th, and 17th, he testified after Weinstein's motion. So everything from that point, all of his testimony has to be wiped out. That's what he did. He did ask for that, bro. I think you might have missed it. And then Judge Whitaker told him to put it in writing.
And he put it
Because
in
what he
writing. He put it in writing last week because he put it in writing. And when he put it in writing, he also put that he wanted Judge Whitaker to admonish the jewelers that they had to erase the memory of the thing, take their notes, all of that kind of stuff. He clearly asked for Mr. Copeland. I think that was one of the first motions he wrote again after she gave them that Tuesday deadline. So he
and
did put it in writing.
what you just said,
Because
Sarah,
so if
what
you
you just,
look at the state's response, that's what the state was talking about. That the basically she was saying that the judge never ruled on the fact. She just basically ruled on there was nothing wrong with the ex parte meeting. She ruled on that Judge Glanville basically said everything lined up. This number one, number two, number three, he met all the criteria. So she just ruled on that. Well, I don't have to go into anything else.
I think what you're mixing the ex parte and the testimony together. What Brian Steele was asking is for the testimony to be thrown out, not what was said at the ex parte hearing meeting, but his
Yes,
Well,
but
testimony.
I think what Jay is now saying, this is what I gather from what you're saying, Jay, is that in the state's response and their response to say that Judge Cross ruled that the change of the recusal had nothing to do with the ex parte. And so what you're saying is if the ex parte was valid, right, then there would be no reason to grant the motion of anything after the 12th being taken away anything after the 12th being taken away because the ex parte was not
it was
out of
valid
order or
based on the
whatever.
judge's eyes. The judge did not rule it was not valid.
But
She never
what
touched
I
that subject.
yeah, but what I gather from what Weinstein said in his motion, or what Steele said about Weinstein's motion is once he filed the motion to recuse, the judge and Judge Glanville denied it, and he went on with testimony. What he's
Yes.
saying is, according to Georgia law, once that
So
recusal motion was filed,
yeah,
all
what I get
testimony.
all that what you're saying, but all I'm saying is this is the nutshell. Woody is going back and testify, correct?
Maybe
What I'm
I,
trying to
I
do is if you file what I'm talking about, he cannot testify. He's been tainted. He cannot testify. And the case has to
okay,
be dismissed. You don't want him to testify.
right, and that's where the motion for mistrial comes in.
Yeah. So and that's the whole nutshell. See, you don't want him to come back and say, okay, that you don't want him to come back at all. I don't want to cross his animal and I don't want this jury to ever see him again. And I don't want nobody to come back. This is it. This case has to be dismissed
But
because
here,
he's been coerced. So he's going to always be coerced. He's always a coerced person. If you can, you know what I'm saying?
right, but
You
you know
can't
what?
undo a coerced witness.
No, you can't. But I say this, and Miss Sylvia, you there, so I don't think nothing what he said on the stand hurt the defense at all.
No, it didn't. But still, that you can't weigh that. That don't have to be weighed at all. It's
Right. No, you're right. You're right.
yeah.
I agree with you. I
So,
agree
and
with
that's
that.
what I'm saying.
I
These
think
motions is not saying that Woody ain't coming back to testify. We need one to say he cannot completely because he's been coerced. That's what we want.
I think that Woody getting on the stand introduced some videos, and those videos hurt them, not necessarily what Woody said out of his mouth. His the pure willingness of him complying, getting on that stage and putting himself in a place to be impeached, to get them videos in, which is all they wanted. And then the way that Judge Glanville was letting them get in, like, I'm glad that that's kind of done with because he was gonna they were ruling on portions of the videos, but he was gonna let the whole thing play out and then just mute the portions where they didn't want to hear it, knowing that somebody was gonna mess up and all that. It was like a whole ish show. Like the way he was ruling on that was just bananas. And I don't believe that that will be the case with this new judge, thankfully. But I
You
think the
know,
whole point of Woody getting on that stage was not for Woody, was for them videos. That's all they
yeah,
wanted.
of course. Especially after he got up there
and he said he went against the prosecution. But how could y'all not know that? How could they not know? And he said in the ex parte meeting, remember when him and Hilton was going back and forth? He said, I told you Tuesday, Wednesday, and Thursday, I was pleading the fifth.
Yeah.
And like,
And
whatever, I
that's
forget
another
what it
thing.
called.
That's another thing. They automatic knew that boy was pleading the fifth. That's what I ain't gonna get. I did not get that.
But like Shell just said, they knew it, but they wanted those interrogation videos to come in. But even that, he said, I was lying to them. I was saying anything to get myself out of trouble. So I would say anything they wanted to hear, I said it. He kept saying it there. That's when he got to start saying, I guess. And then he said,
Miss
well,
Sylvia, you want to talk to us about Boosie? I know that's another case you track, and I know they was asking for it in the chat.
we can't hear you, Miss Sylvia.
Whose baby is that? The baby want
No,
to say hi.
I'm not doing two cases at the same time. I'm going
Oh,
to
okay.
end this live and then do the other one on Boosie.
Yes. Okay. Oh, he left with the baby. You can
Yeah.
finish.
And can I just say this one thing, and we're not going to really, but remember we was talking about the difference between mistrial and dismissal?
Mm-hmm.
And somebody said, well, if it's dismissed, they can't bring it back up. Well, Boosie's case was dismissed. But if whoever this person is in the chat said that he was re-indicted, then that doesn't mean he can't be recharged, because if what they're saying is true, the case was dismissed,
We're not
and now
talking
they,
about Boosie right now.
huh?
We're not talking about Boosie.
No, not about Boosie, but the fact when they're talking about the difference between a dismissal and a mistrial. When they're saying a dismissal couldn't be brought back up, I only use Boosie to make the point that a dismissal can be brought back up if what that person in the chat said was true, and he's re-indicted. That's the only reason I brought Boosie up.
Remember it said with prejudice. With prejudice mean they can't bring it back up. Without prejudice, they could bring it back up.
Right, and that's what I was saying. But I think somebody made the point that a dismissal is automatically with prejudice. I think somebody was saying that, and that's not true.
But remember, we're talking about federal and states. Federal is totally different from state. They're a little bit different.
Right. Right. I definitely understand that. But yeah, so I don't to what Jay was just saying, I don't see Woody getting back on the stand, because I don't believe there's going to be a trial. Once these oral arguments are made from these motions that everybody filed, I don't see it being a trial from this point on, or from the point after the oral arguments are made.
Okay, y'all, I'm about to end, so because I got the information for the Boosie side, and I can come back and bring it to you guys.
Go eat lunch first, Miss Sylvia, please.
Let me tell you something. Let me tell you something. I was eating while I was hiding.
Oh, you said I'm not gonna play myself today. Yes, she tore that plate up. Was that your leftovers from yesterday, or is that?
No, I made me some steak and some Brussels sprout. Sure did.
Yes.
And I muted myself. That's why y'all didn't hear me. I was gone for a little while with y'all. I cooked and everything.
All right, cool. Well, we'll
Same
see.
here, Miss Sylvia. When you told them that you think that was Mr. Jones, I was eating a little bit of watermelon.
And chat and panel, when
You
she
was eating
come back
watermelon?
on topic. Come
A
back
little
on
bit.
topic.
Yes, please, y'all chat. Let's not. Okay. I'm gonna have a conversation with y'all. Y'all be getting in the chat, fighting with each other. I'm gonna start beating y'all up. Seriously. If y'all don't stop that stuff in there, really, guys, stop it.
But sometimes Miss Sylvia, I'm a defender because I be petty in the chat too.
Yeah, you do.
I do. I know. I'm owning it. I'm owning it. I'm just telling you. Sometimes, Miss Sylvia, we just have banter between ourselves, like between the person we're talking to, and we get it. Sometimes it's not all bad. Sometimes it's just fun, kiki. That's what we do sometimes in the chat.
Fun kiki causes them to have some sort of stuff going
Feel
on.
some kind of way.
Yeah, folks speak, and then they thinking you're talking to them, and folks make because you're gonna have to do at when you're talking to a person because then other people
can't do that sub. You can't do that sub shade. You have to like at so they know.
So they know you're talking to that person instead of the other person. Because
I got one thing to say for you go, Miss Sylvia. You just said talking about beating somebody up. You do that, you'll definitely have Max Shard as your defense attorney.
Remember, he told me to go to a crime.
Go commit a crime. So you finna commit a crime.
He said, "Did you call his phone? did you, Miss Sylvia? You might have to start memorizing some numbers, okay? Because you like to get snappy sometimes. I hear these people in these YouTube streets want some. They want some beef.
They all want me.
You might have to start memorizing some numbers. Just having them in your phone may not work, okay?"
They be coming after me. Even my people in the chat, they be coming after me. And I'm like, look, I'll say one or two things and then I'm done. I'm not going to go back and forth with people. I'm not going to fight with them.
Well, Miss Sylvia, you remember I defended you the other night. I was in the chat. Remember that guy was talking about why your house looking empty? I was the one that asked why you worried about what's in our house.
In my house. I'm like, come on, what's wrong? I like an empty house. That's just me.
People don't. Everybody is not a hoarder. Like people stuff clean and spacious and like just have what you need. Like I don't want no house look empty. Who said that?
Some guy.
At least she got a house to be empty. At least she got a house. How about that?
No, some guy in her chat was like, why your house look empty? So I asked him, well, why you worried about?
No, he asked me, my husband take all the furniture. That's what he asked. Did my husband take all the furniture?
What is he gonna buy you some? Tell him to send you his Amex over so you could buy some more. Yeah, it's empty. And what he know about your husband? Oh Lord, let's end this chat, child.
Yeah,
okay, one more thing.
One person came on my chat today, and they said, "I thought you don't go to church on Sunday." Because you told Ernesto that you go to church on Saturday, but because I went to church with Woody on a Sunday.
Because you can go to church whenever the F you feel like going to church.
Okay, hey, for you get too aggressive, Shell.
Huh?
Before Shell get too aggressive, I just want to thank her ahead of time for paying for your lunch on Tuesday on my behalf.
Oh, you see how he tried to be dirty? He tried to be sneaky on that one, Shell.
Don't be making wagers that you cannot deliver on, Mr. Jones. Okay.
If I lose, I will bow out gracefully, and she'll be eating on me.
All right.
No, don't be trying to give me a dollar menu either.
Right. Don't be sitting you with the $5. You got the $5 meal.
Yep. You know what?
And make sure you send enough for delivery, because she needs it sent to the courthouse because this Judge Whitaker is on time. Okay. She don't have an hour and a half.
Nope. See, that's where you wrong. Because if I recall, Judge Whitaker said there will be no more eating in her courtroom.
No, but I'm saying the time. She needs enough time to.
You see how he's trying to slide himself out of there already?
Yeah. He gonna say you can't have lunch because Judge Whitaker said no eating in the courtroom.
she can have lunch. She said they have a cafeteria, so I guess she can send you.
She eating cafeteria food. See, we was gonna get you enough. I was gonna get you enough that you could have got your DoorDash delivered to you, but
he wants me to get the cafeteria discount.
Okay. They probably don't even align with your diet.
He wants me to get lettuce, a piece of lettuce.
No, ma'am. I want you to get whatever your appetite tell you to get.
That's
All
I
right.
won't. All right, I
I'm
enjoyed
out, Miss
y'all.
Sylvia.
I'll
I'll
be
check
back,
you on
Miss
Lucy.
Sylvia.
Yeah, we gotta do Boosie's thing. I gotta end this live. I'll set it up.
Okay. Hey, I appreciate y'all. I had a good time.
Yeah, thank you for coming up. I appreciate it. Thank you, Shell.
All right. See you later, Miss Sylvia.
All right, hon. See you later, guys.
Later.
Guys, may the Lord watch between me and thee while we're absent one from another. Have a good one. Later. Love y'all. Bye.